We are here for a pretrial detention, 24 CF 1257. Mr. Leonard is present with his counsel.
Yes, Your
By
Honor.
yourself?
Jared Sutherland.
Okay. And Ms. Leone, you're here for the state.
Yes, Your Honor. And I have filed a motion for pretrial detention, although the case was set already for pretrial detention automatically because of the charges. Trafficking in fentanyl is considered a serious dangerous crime per 907.041 Florida statute. I have here Investigator Skelly to provide testimony as to the type of evidence that is present in the case, the probability that the defendant committed the crime, describe why the state believes that he is a danger to the community, possibly a flight risk, and therefore why he should be kept without bond pending resolution of the case.
Alan, do you want to give me any?
Yes, Your Honor.
I just want to know what your position is.
Yeah, the defense's position is that Mr. Leonard should be provided a bond in this matter of no more than $10,000. The reasoning is this charge has been added around 8 months after the original arrest of Mr. Leonard, and the same facts and circumstances have been present the entire pendency of the case. Mr. Leonard has shown up for every court appearance. He is not a flight risk, and he has not been a danger to the community on the current conditions of bond that have been imposed in his case. He has not been rearrested for any new law offenses. He has not violated his conditions of bond. So there's no basis to assume that he automatically becomes a danger to the community just because an additional charge has been filed against him.
Your witness?
Yes, the state calls Investigator Rachel Skelly, Crestview Police Department.
Yes, sir.
Go ahead, take a seat. Make sure you speak into that microphone, please.
Yes, sir.
Thank you. Go ahead.
State your name for the record.
Rachel Skelly,
Where are you employed?
Crestview Police Department,
And what's your position for the Crestview Police Department?
an investigator.
Did you participate in an investigation on May 30, 2024, involving the death of a person?
Yes.
Where did you respond?
767 Majestic Drive in Crestview.
What information did you have right prior to responding from dispatch?
I was not the initial responder. I was in investigations. The patrol division responded initially that we had an unattended death at this address, and CID, which is Criminal Investigations Division, is called out for those for mostly every single one.
When you arrived, did you respond to the crime scene?
Yes.
Did you have the opportunity to speak with any witness?
It was multiple people on patrol and with Criminal Investigations Division that spoke with the witnesses involved.
Did any of the witnesses have personal knowledge of the events that took place on May 30, 2024?
Yes.
And could you tell the court at least some of the statements that you were related?
So at about 5:30 that morning, a neighbor went outside to go to work, and the defendant went to him asking for help to get the deceased in this case into a vehicle to take him to the hospital. The witness said that the deceased was cold to the touch and that they have a bigger problem and need to call 911. The witness has, in his own written statement, also stated he asked the defendant, why haven't you called 911? And he stated, because I don't want the police searching my house.
What other information were you able to gather at the time about the crime?
So a friend of the deceased, Mr. Brian Van Benthuizen, he had gone to the defendant's residence on Majestic Drive here in Crestview and knew that he was a narcotics dealer to purchase narcotics from him. He wanted to purchase cocaine. And they got the cocaine from the defendant, consumed that, and immediately passed out. That was on the 29th of May, around 5 p.m., that they consumed the cocaine. And then the next day, they find him deceased. Mr. Van Benthuizen stated that the defendant and his girlfriend were going upstairs, gathering narcotics and items, coming downstairs, going out to their car and hiding narcotics out in the car. And then it was later observed on video that the girlfriend of the defendant was being a lookout to make sure police weren't coming over to their vehicle. And the defendant was removing the narcotics from the vehicle and into a dog waste bin. This is observed on a home surveillance footage provided by another witness. And I observed this footage as well. Once this information was provided to the police, I went and looked in the dog waste bin, and there was numerous items of narcotic paraphernalia and other narcotics. We didn't open all of it on scene due to the high winds that day, so we took it and put it in secured it in my vehicle, including the dog waste that was already in the bin, and everything was searched through up at the Crestview Police Department.
Do you know who was residing at that property at the time of the incident?
Yes, the defendant, Mr. Leonard, and his girlfriend, Kristen Roberts. They were the residents of that place.
According to your knowledge, was the girlfriend present at the time of, I guess, the victim passing away?
So on the 29th of May, she was at work when the deceased and Mr. Van Benthuizen came to the house. The defendant was present, provided them with the narcotics, and then later on that evening, he had left the residence to go pick her up from work down in Destin. The girlfriend returned back around 10 p.m., so she was not present when they consumed the narcotics.
You stated that you reviewed surveillance footage from the home cameras?
From various neighbors, correct. They provided video surveillance footage to us.
Did you collect it from them?
We send them a community link, and they send it to evidence.com.
So in other words, they
That's
upload it
the
directly
Yes.
to the link?
Yes.
And those videos are available to law enforcement, right?
Yes.
Your Honor, this time I would like to ask to publish the surveillance video.
I would object to, there's no one to authenticate the videos, who's here, to authenticate the system that the videos were taken on, to authenticate the system was operating and is accurate and is showing everything that it needed to show. The state would need to have the owner of the system to be here to introduce those videos.
Pretty sure there's case law that talks about kind of video speaks for itself.
Yes, but the objection would go to the correct operation of the actual systems that the videos were taken on. There's no one here with knowledge that the video systems were operating correctly and are showing what they shown on the day of the incident, and to testify that that was what they observed on the day that is being alleged to be shown in the courtroom today. We would need the owner of the video system to testify.
And the officer already testified to what she saw on the video, right?
That's it, and I wanted the court to see what is available as evidence to the state.
I'm going to sustain the objection. I think I've heard what I need to.
So, investigator, state again what exactly you saw in the video.
In the specific video, you can see the defendant and his girlfriend walking away from the residence due to it being a crime scene now, and we secured it. They walk away from the residence to their vehicle, their shared vehicle. It was registered to only Kristen Roberts, but he had regular access to it, and it was, she also confirmed that he regularly drove it. Miss Roberts goes to the dog waste bin and grabs some trash bags from it, comes back to the vehicle with the defendant. The defendant is seen messing with items in the car, and then goes from the vehicle to the dog waste bin and putting items inside, which include like the black bags from the dog waste bin in a box and stuff like that.
You said you personally collected that waste from the trash can?
I personally collected that, yes. The bag in its entirety.
Did you recognize the item that you retrieved from the trash bin? Was that the same that the defendant appeared to carry to the trash bin?
It appeared so.
And are you aware about the FDLE results on that substance?
There were multiple different types of substances inside of that box. However, there was a specific one in this case that we're talking about today. Mr. Van Benthuizen, the friend of the deceased, described the bag that was brought down from downstairs that contained what he thought was cocaine in it as a plastic bag that was white in color. That bag described was the only one found that was described like that in the box of items that was taken from the car to the dog waste bin by the defendant. Was sent off to FDLE for testing, and it came back, I believe, as fentanyl, and I'm not sure exactly the weight on that.
Do you recall, by any chance, if you can refer to your records, the item number, FDLE item number or agency number, the exhibit?
So, you're gonna have to give me just a moment. I apologize, there's a lot of property in this report.
Investigator, would it help you if I showed you the, would it help you recall if I showed you the FDLE report?
Yes, it would. And I just realized this report doesn't tell me what the number is on here.
May I approach the witness?
Yes. Yeah, this is Agency Exhibit 38.
And what's the weight on the fentanyl?
The weight says 8.13 grams.
Thank you. Investigator, based on your training and experience, do you believe Mr. Leonard is a danger to the community?
I believe that.
I'm not sure if you are or not. Are you familiar with his prior record?
Yes.
Could you please explain to the court the material charges that he has in his prior record?
I can't recall the exact wording on the charges. I do know he has spent some time for trafficking and other narcotics.
Thank you. No other questions.
Ross?
Officer, you testified that you observed Mr. Larry placing items into the dog waste bin. Is that correct?
Yes, sir.
What items exactly were those?
The ones that were located?
No, the ones that you observed on the video, him
On
placing.
the video, he was carrying bags, like black bags, and a smaller box-shaped item.
Okay. And where were the bags of the fentanyl found whenever you located it in the waste bin?
Inside of that box.
Box.
Yes, sir.
And were you able to see into the box whenever he was carrying the box to the waste bin on the video?
No, sir.
Okay, and did you review any subsequent videos of any time frame after you observed the video of him placing the box in the waste bin?
I don't believe so.
And so, in that waste bin, was it accessible to everyone in the complex?
Sure.
So it's possible that someone could have came and put those substances in the box after he put it in there?
One of the substances that was in that box was specifically described by a witness, and that was located in the box.
And did you see any photographs of the substance in the bag that that witness was describing whenever he was describing it to you?
No,
So are you?
but it matched his description.
Was the co-defendant also placing things in the waste bin?
Let me verify that. I know she went and retrieved plastic bags from the waste bin station, and she was being a lookout while he was performing those actions.
Did you ever see her lift the lid of the waste bin?
Just give me 1 second, I apologize. I cannot recall that at this point.
That's all the questions I have for you, ma'am.
No other questions.
Thank you, sir.
No other witnesses. No, just argument.
All right. Mr. Sullivan, any evidence you plan on putting on?
No, Your Honor.
All right. Argument, Ms. Leone?
So, Your Honor, as Investigator Skelly has testified as to the nature, quantity, and the value of the evidence that is already present in the case, there is a very high probability that this defendant would be convicted and beyond a reasonable doubt for the charges of trafficking. There is undisputed evidence that he had total control of those drugs. Yes, the bins could have been accessible by other people, but there is no evidence in the video itself that anybody else went after the defendant prior to law enforcement going there and retrieving the bag from it. So nobody tampered with it. Additionally, Investigator Skelly testified that one of the witnesses was able to describe the controlled substance that was in the bin, and she verified that indeed corroborated the testimony of the witness. As the court has heard, there is video evidence depicting this defendant going to the trash bin with the bag or box, placed it in the trash bin. Yes, he was aided by his girlfriend, who's been charged also in the case, not with the trafficking, but with the tampering, because she actively assisted this defendant to dispose of the drugs. We also heard from Investigator Skelly that one of the witnesses in a sworn statement stated that the defendant specifically said that he wanted to avoid the law enforcement going to his house to search his house, obviously because he had possession of drugs. What I would like the court to know about this defendant being a danger to the community, his prior record shows 2 convictions for trafficking. One, trafficking in cocaine, 28 grams or more, and the other one, trafficking in heroin, both first-degree felonies. This will be his third charge of trafficking, and it obviously shows an increase in violence and danger because at this time, someone lost their life. There is testimony, as Investigator Skelly has mentioned, of the victim's friend. The victim's friend stated that he took his friend, the deceased, to purchase drugs from this defendant. The victim had come from out of town. They consumed those drugs with the defendant, thinking that they were buying cocaine. Point is that they both passed out. The friend woke up, the deceased victim did not. What's important to notice, again, is that the defendant knew that he would have been in trouble, and he actually tried to hide the body of the deceased person. He was stopped only because a neighbor told him to stop, and they said that they were going to get the law enforcement involved. Fentanyl is causing, as this court knows already, a lot of deaths in the United States. And it's so dangerous.
Hold on.
Yeah, I'm gonna object to the broad argument of fentanyl causing lots of deaths. I would ask that I object to that broad argument and think that the purpose of closing arguments would be to argue about the specifics of the case, not overall broad allegations of what fentanyl is causing in the United States.
I do believe that it's very important.
The court's well aware of that. It's a fact.
The state believes that he's a danger to the community. He may be he is a flight risk. He's facing a minimum mandatory sentence. The manslaughter by overdose is still being investigated. The state believes, again, that to protect the community, this defendant is to be held without bond.
Yes, Judge. First, I want to reiterate the procedural aspects of this case. Mr. Larry has been out on bond on these exact facts for 8 months now, preceding the addition of this trafficking charge. He has not committed a new law violation. He has not violated the conditions of his bond, and he has attended all of the court dates he's been required to attend. He even attended the last court date, as you were here as well. From the testimony that we've heard here today, he was observed putting a box and/or bag in the trash can. There was no way for the officer to observe the contents of the box that he placed in the trash can when he put it in the trash can. There is uncontroverted testimony that that trash can was accessible to many different people. There is no evidence, and none was reviewed, of any subsequent happenings of that trash can after it was observed that by the officer who testified that Larry placed the box in the trash can. So we don't know if someone came afterwards and placed substances in the box that he placed in the trash can. The co-defendant in this case has been, as the prosecutor said, is charged with tampering and conspiring in this offense, allegedly. But she is not being held without bond right now, and she is not being charged with trafficking in fentanyl. But the same facts apply to both these cases, and she is out on bond right now. The defense would ask that the court consider all of those factors when deciding whether or not to grant the state's motion in this case, and would request a reasonable bond of no more than $10,000.
Just want to mention the standards the court needs to follow. Under section 907.041, 5C5 says that the court may conclude that the defendant poses a threat of harm to the community if it finds that the defendant is presently charged with a dangerous crime, and he is, per the statute. There is a substantial probability that the defendant committed such crime, and I believe that there is already, based on the testimony, and even the fact that the girlfriend wasn't charged with the trafficking. It's because she wasn't even present at the time that the drugs were given to the victim. Obviously, the sale of those drugs is a.
I'm going to object to any characterizations of victims in this case. There are no victims in this case as of now. It's a drug trafficking charge and a tampering charge.
The deceased
You're
person.
objecting to the terminology.
Yes.
Yeah. Okay.
Proceed.
So I believe that shows a disregard for the safety of the community. As I said, he has prior records showing trafficking in drugs, and apparently he hasn't learned anything from the punishment that he had to face when he was charged with the other trafficking. And obviously, there is a great risk of physical harm to persons, as demonstrated by the facts. I believe that there is more than enough ground for this court to order pretrial detention of Mr. Leonard.
All right, I'm looking at 907.041, and I want to get to 5D. It says if a defendant is arrested for a dangerous crime that is a capital felony, life felony, or felony of the first degree, which this is, correct?
Yes.
Everyone agrees to that. And the court determines there's probable cause, that's what gets us to today. But the next part of that paragraph states, if the court finds a substantial probability that the defendant committed the offense and, based on the defendant's past and present patterns of behavior, consideration of the criteria of 903.046, which is bond considerations, and any other relevant factors, that no conditions of release or bail will reasonably protect the community from the risk of physical harm, ensure the presence of the defendant at trial, or assure the integrity of the judicial process, the court must order pretrial detention. Well, I think it's clear, I think, Mr. Sutherland, you agree with this, that this is a dangerous crime, it is trafficking, it is fentanyl, and it is a first-degree felony, so I think this paragraph D applies.
Yes, sir. I
do find substantial probability that the defendant committed the offense. He's got prior acts or convictions of trafficking in cocaine and heroin. The evidence here today was that people went to his home to purchase cocaine. It turned out it was fentanyl, or at least that seems to be the assumptions that can be made based on what I've heard today. And so the things I have to look at is protecting the community from the risk of physical harm. The testimony was that he was essentially selling or at least distributing narcotics. Somebody died due to that fact. He's not charged with that, but obviously that's certainly a risk of physical harm. But also assuring the integrity of the judicial process. He's also charged with tampering with evidence, where the allegations are he was trying to move a dead body out of his house that the person had overdosed in his home, and he was trying to hide the drugs, which were an instrumentality potentially of that death. So the fact that there's a concern about risk of physical harm as well as integrity of the judicial process, I believe the court must order pretrial detention and will do so.
Thank you, Your Honor.
Thank you, Your Honor.
Is the case set for the next pretrial conference on February 26th? Just to make sure.
It is.
Okay, thank you, Your Honor.
I'm sorry. Well, it's set for February 24th, obviously, because he's in custody, it would be on that. On the
Yes,
26th.
that's fine. Thank you.
All right, thank you, Mr. Sutherland. Ms. Leona, do you have one of those orders that we typically do on pretrial detentions?
I'm sorry, Your Honor.
Do you have one of the orders that we hand write out for pretrial detention?
no,
I'll get one. I just didn't know if you guys carried them with you. I'll have Katie print one out.
I wonder if we should have them, Your Honor. We don't have them, but we could. We can ask the clerk.
Got all these cabinets and drawers. I'll put some in there.
Okay.
I'll just have to get some of them done right now.
Yeah, I never had it.
Well, why don't we do that, because it looks like I've got a warrant that looks pretty urgent. They just contacted the office, so let me take a break until 1:30, and so I can go resolve that warrant. Yeah.
All rise, please.
Dixon.
Council relax.
He doesn't.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Is 2 blocks from the courthouse on Crestviews historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored
got our 1:30 docket, which is our, oh. I was a 1:30 docket. All right. So everybody, this is our arraignment docket, which this means it's sometimes referred to as a plea day. What I'm going to do is call everybody up there individually. When I call your name, just come up and stand to this podium. Over to my right, it'll be your left. I'm going to verify who you are, tell you what you're charged with, talk to you about whether or not you want me to appoint a lawyer. Just understand that everything in this room is recorded, which means that anything that you say can and will be used against you in your investigation and prosecution of your case. So don't talk about the facts of your case. If you do have any questions, I'll try to answer the best I can. I can give you information. I can't give you advice. All right. Samuel Allen.
Charles Russell, Public Defender's Office. Judge, Mr. Allen's present and approaching. Case number is 25 CF 42. The state has filed an information. At this time, we're going to enter a plea of not guilty, request trial by jury, and 15 days for any pre-arraignment motions. I believe the clerk's already set it for a pretrial on 4/28.
4/28 at 9 o'clock.
Okay.
Well, let me rephrase that, though. Y'all are at 1:30 that day.
1:30?
All right. So, Mr. Allen, make sure just be here at 1:30 that day. I'm trying to split things up so certain groups don't have to be here at certain times. Otherwise, it ends up being a pretty long day. So that'll be April 28th at 1:30.
Sure. Just call next week, okay?
Make sure you stay in touch with your lawyer. We'll see you back on that date.
Yes, sir. Thank you.
Is it Levon Ansley? Guess I should.
Charles Russell, Public Defender's Office. Judge, Mr. Ansley's case number is 25 CF 35. State has filed an information. At this time, we're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions. And I believe the clerk's already set it for a pre-trial on April 28th.
Oh, can I say something?
Hold on. I'm going to come in.
You get out today?
No. Here, this is for you.
Why Mom get out today?
All right, Mr. Ansley, you're going to come back for a pretrial conference on 4/28 at 1:30. If you're still in custody, that will be actually April 30th at 9 o'clock.
But the other day I got dismissed and the other judge, Jim Ward, and I thought I was supposed to be able to get out that day, but they never let me get out.
Okay. We're going to talk about your case when I come see you, okay?
All right, Justice Barfield.
Charles Russell, Public Defender's Office. Judge, is it Barfield Justice is
Yes.
your last name? Okay. That's for you.
Oh, I'm sorry, it's Terry Barfield Justice. My mistake, sir.
Information's been filed, Judge. At this time, we're going to enter a plea of not guilty, request trial by jury, 15 days to file any pre-arraignment motions, and I believe it's set for April 28th pretrial conference.
Yes, Mr. Barfield Justice, come back on April 28th at 1:30. You might see something that says 9 o'clock. Make sure to just come in at 1:30, otherwise you're going to be waiting quite some time.
All right. Also, before I got this court date, I had a court date of February 13th. I was wondering if that was still active. If I still needed to
Do you have another case?
I don't know if it got changed or something. I just need to make sure.
Okay. No, it's always better to ask. Yeah. Let me see if I can pull anything up. I don't see that date anywhere, but the only other cases, you had a couple misdemeanor cases last year that seemed to have been resolved. But I'm not sure if it was in that, but your court date for this case is going to be April 28th at 1:30. So I don't see anything that shows that date, but
a little earlier to today, but I just wanted to make sure I didn't have to.
I don't see it. All right, thank you. something. All right, Sandra Beerley. Byerly.
Judges, Ms. Byerly, case number for the record is 25 CF1. State has filed an information. At this time, we're going to enter plea of not guilty. Request trial by jury, 15 days for any pre-arraignment motions, and I believe it's already on the clerk's docket for April 28th pretrial conference.
Ms. Byerly, come back for your pretrial conference on April 28th at 1:30. However, if you're still in custody at that time, they'll bring you back on the 30th. All right, Donald, is it Desculo? Last name is Discuillo.
And I don't see him on the jail list, Judge. Can we just pass him to see if he shows up?
We'll pass him, see if he shows up.
Okay.
All right, Adam Frederick. Mr. Frederick, you're here in 25 CF5, charged with driving while license suspended with prior convictions. Do you understand that charge? Can you afford an attorney to represent you in this case?
No, sir.
All right. I'm going to provisionally appoint the Public Defender's Office to represent you. You're going to have to fill out one of those application sheets that's in front of you. Go downstairs and turn that into the clerk's office on the first floor before you leave today.
Judge, at this time, state has filed an information. We're going to enter plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions, and ask that this be put on the April 28th pretrial conference.
April 28th at 1:30. Be back on that date and time. Mr. Frederick, stay in touch with your lawyers so they can help you with your case.
Sir.
All right, thank you. Jackson Harrell.
Mr. Harrell, coming up. Judge, Mr. Harrell's present in the courtroom and approaching. I'll be entering a plea of not guilty on his behalf. Request 15 days for any pre-arraignment motions and trial by jury.
Who's here today with Mr. Harrell? All right, April 28th at 1:30, Mr. Harrell.
Thank you, Judge. All right, Mr. Harrell, I gave you my card. Make an appointment, okay?
All right, Alicia Havens. Alicia Havens.
KPS judge.
Looking at the arrest report, it shows today's date, February 6th at 13:30 or 1:30, and this address via KPS, no bond until she gets the first appearance. It wasn't. All right. All right, Donald Jesperson, I think he's in custody. All right, Mr. Jesperson, you're here charged with aggravated battery in 25 CF 36. Do you understand that charge?
Yes, sir.
All right, can you afford an attorney to represent you?
I got an attorney.
Say again?
I have an attorney.
Who's that?
Brad Stewart.
Brad Stewart. Is he supposed to be here today?
I thought he, I don't know if he was aware I had court today. I thought I had court on February 24th.
You have another pending case?
Yes, sir.
That may be it.
Mr. Stewart represents him on the other existing cases. We had depositions a couple days ago. He knew of this case, but he hadn't formally entered his appearance, he told me.
He hadn't?
He has
formally?
not, yeah.
It looks like he's on your previous cases, but not this current one. I don't want to talk about any conversations with him that you may have had, because those would be privileged, but have you talked to him about representing you in this case?
Yes, sir.
Okay. Otherwise, I can potentially look into appointing you a public defender, but if you've got him and you don't want one, I won't do that.
I talked to him on the 10th. I think he said the 10th he's supposed to come see me.
Okay. All right, so I'm going to keep you as unrepresented at this point. I'm going to have you come back for your pretrial conference. We want to put this on the 24th just to keep it together with the
It
other
would be
ones?
fine for me. Or
All right, let's move your pretrial conference to April 28th. We'll put it on for 9 a.m. so that way he can be here for that. You can maybe move to a different time or date if he's not representing you. All right. Thank you. Michael Manning.
Give me just a second, Mr. Manning. Judge, we're going to enter a plea of not guilty at this time, 15 days for pre-arraignment motions, and go ahead and set it for trial by jury. Madam Prosecutor, I'll talk with you further about it.
April 28th at 1:30 if you're released before then. Otherwise, it'll be April 30th at 9. All right, thank you, Mr. Manning.
Okay.
Not on my docket, but it's on my smart. Let me see. Has he been served with it? Okay. Okay. Is there a Michael Lentini here, by any chance? All right, come on up, sir. He's not on the docket, but I think I had just signed an order regarding a VOP. Can I see that again? Mr. Lentini, there's an affidavit that you violated your probation regarding some costs. Probation have a record of that here today, or?
Yeah,
Hold on just one second.
I'm a patient in Bridgeway.
I don't. I can check, but if this is the one I'm VOP, and then we immediately ask for the VOP.
I don't, so the affidavit was filed on January 17th.
If we could pass them for a second, Your Honor, we'll.
Why don't, Mr. Lentini, talk to probation real quick and see if they can get it figured out. But I just got an order to have him appear so he wasn't arrested just to come into court.
Okay, thank you.
That's Steve in case I need that. All right, Stephanie Medina. It looks like that one was handled, maybe. Okay. You have that? Okay. Vincent Robledo. This is 2025 CF38. Mr. Pronounce it for me.
Robledo?
Robledo?
Yes, sir.
You're here charged with larceny by a guest, employee, or contractor from an establishment. That's a new one. All right, can you afford an attorney to represent you in this case?
I just paid for a public defender.
You just paid for one?
Well, I mean, I just paid the $50 down at the clerk's office.
Okay, did you fill out the application?
Yes, sir.
Your Honor,
you
I
filed it?
asked him to go fill out the
Oh, okay.
application.
Perfect. All right, so I'm going to go ahead and appoint the public defender to represent you, sir.
Your Honor, at this time, we're going to enter a not guilty plea, request trial by jury. My understanding is the clerk has this set for April 28th at 9 a.m.
All right. If he's going to be represented by the public defender, it's going to be 1:30, sir.
Yes, sir.
Same date, just 1:30.
Okay.
All right, we'll see you back on that date. Stay in touch with Ms. Rick.
So I'm good to go?
Yes, sir.
Thank you, sir.
This is yours.
Okay.
Okay.
Thank you, Lisa.
Be sure to call.
I will.
All right, Jeremy Schnurr. This is 25 CF 79. I think I received a motion to transfer this.
Your Honor.
Go ahead.
Yes, we did. We filed a motion to transfer to Division, I believe, 1.
That's 2.
I'm sorry, yes, Division 2. And if I may hand the motion and the proposed order to the defendant, because I don't believe he's represented at this time.
Okay. You can do that. Does he have another case there? Is that the issue?
Yeah, probably. He had a lower case number already there. I just don't know. The order should say,
CF 76.
yeah, the new dates, yes.
Let's see. All right, Mr. Schnurr, you're not currently representing this case. Would you like to me to talk to you about appointing a public defender?
I guess so.
What does that mean?
Yes, sir. I mean, I'm not really quite understanding what I'm being charged with. Oh, here it is.
Mr. Schnurr, you're already represented by someone else in your other case, but you want me to appoint you a public defender?
Yes, please.
Okay. I'm going to provisionally appoint the public defender for you, Mr. Schnurr, but Ms. Rivers, this is to be transferred to the south end, so just so he knows it's going to be someone else. I'm not sure who's in that division.
And I am just giving you a public defender card in general, but we will mark it down that it's being transferred, and so the appropriate public defender can come talk to you at the jail.
Okay.
Okay?
Yes, ma'am. Thank you.
He's 2. Is she 1 then? Okay. Every county's different. I've been in division letters and numbers and all right, so that'll be April 20. Well, I'm going to sign the order. Commissioner, you're going to be sent to the division in Fort Walton. Your next pre-trial is going to be March 10th.
Okay,
And I'm signing that order right now.
thank you, sir. Okay, thank you, ma'am. Thank you, Your Honor.
You're welcome, sir. All right. Is it Dana Steverson or Stiverson? This is going to be 25 CF 03. How do I pronounce the last name, ma'am? Stiverson. Okay, that's what I figured. I just wanted to make sure I've got that right. Ms. Stiverson, you're here charged with dealing in stolen property as well as vehicle theft. Can you afford an attorney to represent you in this case? All right, I'm going to provisionally appoint the public defender's office. Fill out that application, bring it down to the first floor, and turn it in before you leave.
Your Honor, at this time, we're going to enter a not guilty plea, request trial by jury.
All right, thank you. Oh, did we give the date? That's going to be April 28th at 1:30. All right, Joseph Talbot. Go.
Your Honor, this is Joseph Talbot. He's before the court on 25 CF 39 on the charge of driving while license suspended. We're going to enter a not guilty plea, request trial by jury. He will be in custody, so it would be the. They're not offering anything yet. I already talked to her. So it was
Is he in on something else?
He just got rearrested, Your Honor, on a violation of probation. She didn't even have it listed because I did talk to her about it.
Is that in this division as well?
Yes, Your Honor.
Okay, when is that set? Do you know?
March 27th, arraignment. VOP arraignment.
So we'll come back on March 27th, and then she'll have something for us about that.
Do we want to put this on March 27th?
Yes, Your Honor.
All right, March 27th at 9 o'clock to run with the VOP.
That's what our goal will be.
Jessica Taylor, is that one?
Your Honor, we filed a motion to conflict off that case.
Looks
So
like Ms. Flowers is on it now. Just a second, Ms. Taylor. So what happened, we appointed you a public defender. They had a conflict, so that you've now been appointed the Regional Office of Conflict Counsel. Have they reached out to that? That just happened yesterday, so. All right, do we have Ms. Flowers' information or RCC's information? All right, so they're going to give you a card from Ms. Flowers. She's with the Regional Office of Conflict Counsel. She'll
Yes,
be
sir.
your lawyer. So I'm going to put you on the April 28th docket at 9 o'clock. Make sure you get in touch with Ms. Flowers well in advance of that so
Yes,
that you
sir.
can talk to her about your case and you can talk to her about strategy and witnesses, all sorts of stuff. So any questions, Ms. Taylor?
No, sir.
All right, we'll see you back on that day.
Yes, sir, thank you.
Angela Watson. We already handled Webster this morning, right?
Your Honor, this is Angela Watson before the court on 25 CF 19. She is charged with burglary of an unoccupied structure and petty theft. We're going to enter a not guilty plea, and I believe the clerk has set court for 4/28 at 9 a.m. I do believe that she will still be in custody, so 4:30.
All right, so the way I'm saying it is April 28th at 1:30 if she's out of custody. However, if you're still in custody, ma'am, it'll be April 30th at 9.
Not guilty would be trial though, right?
Yes.
If I plead no contest, I can maybe get a plea or something, couldn't I?
is there a plea offer?
Yes, it would be adjudicate guilt, 60 days county jail with credit for time served. $2.65 is owed to Dollar General.
Okay, and that's today? I can have that?
Yes, ma'am.
Okay, I'll
Also,
take that then,
The court
please.
costs, Judge.
Well, I'm gonna need a plea form. We'll pass you and they'll bring you back. Okay, he's in custody. Okay. All right, anybody that's here for arraignment or plea day that didn't get called? Do you have something on Mr. Lentini?
Answer on Mr. Lentini? Okay, it's for court costs, Your Honor. The reason DOP was done was because he had a condition that he could do community service work in lieu of his court costs, but he is, have documentation here from his doctor. We don't believe that he can do community service work. He's on limited income and cannot pay his court costs. So the court wants to terminate him and send his judgment, or may I put it to this round?
Sure. Well, let the state take a look at it first.
The state would be fine, Your Honor, with,
Just terminating his probation and sending it to
yes,
collection, I guess?
yes, Your Honor. Even the documentation provided.
Have been considered a successful or unsuccessful termination? Matter. Steve, can you get that?
Yeah, we don't believe the violation's willful, so successful.
All right, so, Mr. Lentini, what I'll do is I'm going to terminate your probation at this point. The outstanding money will be sent to collections, so they're going to try and ask you for that. But it's not going to violate your probation at this point. Okay, so you're done with probation as of, I think it's February 22nd, right? Or we just want to call it today?
Believe that, sir.
Okay. We'll call it today. All right. All right, so you're off probation, but they may send you some paperwork that says you owe that money still. It's just a civil judgment, like lien against you.
Okay.
All right, thank you, Mr.
Thank
Lentini.
you.
Sure.
Call or visit us at browninglawfirm.com.
Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict.
All right. I think I started to say this, but I'm not sure if I finished. Is there anyone else here that thinks they're here for an arraignment or plea date that wasn't called? Just want to make sure. They're going to be a minute, Steve.
That's you guys in here right now. They're going to walk around.
Okay. All right. Anything in particular you want to handle in the? It's a 2:30 docket, but I think we can start now if y'all have anybody. This is why
Judge.
Yes. Gamble's been continued because his lawyer had to be somewhere else, I believe. We have Bradley. Who's handling Bradley, Mr. Russell?
Bradley is mine, Judge.
Judge, I'm going to run back to the office, pull something off the printer for 2:30.
Okay, let's handle Watson first. All right, well, Miss Watson, what I'm going to do, because the offer is 60 days, and you're only about halfway through that, potentially even. So I'm going to bring you back on another court date, have the doctor come speak with you real quick, and then we'll bring you back on February 26th, which would still be within the time that they're offering you.
But they, I thought you gave me the time.
I didn't give you anything yet. That they offered it, but you haven't entered a plea yet. I need you to talk to someone to give you an evaluation first,
What for?
just to make sure you're ready to enter a plea and resolve your case. So I'm going to have you come back on February 26th at 9 o'clock. We'll talk about that. But when someone comes to speak with you, you make sure you speak with them and answer their questions, okay?
Okay.
All right. Thank you, Miss Watson.
Bradley and Tatum both right here. I don't know how.
All right.
Bradley's gonna be very
short.
Could we do Dixon, or is not he? That'd be quicker than the other ones.
Judge, this is David Bradley. Case number for the record is 24 CF 1841. I had set this case for a Nelson hearing. Mr. Bradley had filed it back in September, but we didn't know about it till recently. Before we get into that, I want to go ahead and let the court know that after the case was open, I had a chance to look at it. We do have a conflict of interest, so we're going to have to withdraw. So that would make the Nelson hearing, I believe, moot at this point. But and he's set for the 2/24 pretrial conference, which will give RCC time to get into the case. But we can have the Nelson hearing.
What's the general issue of the conflict?
Can I approach?
If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
All right, Mr. Bradley, it looks like I'm going to be appointing the regional office of conflict counsel to represent you. That's Jennifer Flowers. I do understand your concerns. I've read your Nelson inquiry back from September. I've got a real concern with the fact that there was a motion filed to continue his case in October, which I'm guessing Mr. Bradley didn't know anything about, because this case has been continued for months since the Nelson inquiry. I mean, I just took over the case, as you know, Mr. Bradley, and that was my concern as I looked at it. Now that I'm becoming more familiar with these cases, I'm just going to want to put it out there, and I'm not speaking to the right people right now, but filing motions to continue cases when there's a pending Nelson request is shouldn't be done. I'll leave it at that. And I'm going to need an explanation for that at some point if there's a return. All right, so Mr. Bradley, I'm going to appoint you the regional office of conflict counsel. Like I said, what is he? He's currently set for 2/24, so we'll see you back on the 24th. Can we give him a card of Miss Flowers as well? I know it might not be easy to reach out to her, but I'd really like if we can get in order for me today, or
We'll get that.
at least by tomorrow, Mr. Russell. That way I can get her appointed.
Yes, sir. We'll file the paperwork.
Send it in Word. I want to specifically put on there that they're to meet before that date.
You want it in, what is it called, Word format? So
Word
you can
format, yes, so I can just
adjust it?
add some language to it. Right. Any other
Do that.
questions, Mr. Bradley? No, sir. Okay, thank you, sir. Dixon's a plea, is that what you said?
Questions? Okay.
Hearing on others.
Yes.
I'll agree to the hearing, but so am I still.
Judge, this is Akeem Dixon. Case numbers are 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835, 22 CF 1506, which are all violations of probation, and then 24 CF 1598, which is a new charge. Based on discussions earlier with Mr. Dixon, he was wanting to admit only paragraphs 1 and 2 of the second amended affidavit of violation of probation. The state, when I discussed it with them, was going to ask to have a hearing on the other accusations in the affidavit of violation of probation, and then at some point we'll have a sentencing hearing.
That is correct, Your Honor.
So,
Are we having that hearing today? Okay, I just,
Yes, Your Honor. No, not today. I was asking maybe the 27th at 2 p.m.
okay.
and because the state is going to go forward with the other allegations, Judge, in the affidavit, they did not want to sign this, but this does have the rights and so on that Mr.
to find the VOP affidavit. Oh, I'm looking at the new case, that's why I'm not finding it.
So I'm still having.
July 15th of 24, Judge, is what I have.
When did he go on probation?
The last time was October of 23. Yes, October of 23.
That's when the suspended sentence happened?
Correct, Judge.
Okay, so what is he wanting to admit to again, which
The
grounds?
first two paragraphs, which are the positive drug tests.
Okay, but as far as the failure to report, failure to, refusal to submit to drug testing, and changing the residence or absconding, oh, and then the new arrest, all of those things are gonna be the hearing?
Yes, sir.
Yes, sir.
Pass it up, sir. Mr. Russell, Ms. Leone. Our case?
Yes, sir. Ariana.
Ms. Leone. So every count across these is a third-degree felony except for one. Do y'all believe that there's anything I could give him other than the 60.1? I mean, I'm not even sure I can give him that if they're all or third-degree felonies. The suspended sentence was 60.1 months.
Yes.
And the 60.1, Judge, as I understand it, because I wasn't the attorney at the time, is based on the score sheet that was filed at that time, and that's where the 60.1, the odd number, comes from.
Okay. But I'd be limited to that, correct?
On the VOP alone, yes, Your Honor, you would.
You mean as far as, could you give less than that? Is that what you're
I
asking?
can give less than that, I know
Right.
that, but I can't give any more. I just want to make
Correct.
sure he knows what he's pleading to, because
Yes,
I
sir.
saw the one second-degree felony that I can't give him any more than that. I'm not saying I would or wouldn't, I just want to make sure, we always have to explain what the maximum penalties are. So I want to make sure that we're all on the same page there. What's going to happen with the 24 case?
The new law violation?
Yes.
We'd ask that they all travel together.
It's just going to go along with it, but he's not entering a plea to it today.
Right, no, I don't
All
think
right,
so.
just want to make sure that we're all clear on that. All right, Mr. Dixon, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. I've been handed a violation of probation plea agreement. It involves 18 CF 2695, which is 2 counts of possession of controlled substance, third-degree felony. 19 CF 562, possession of controlled substance, third-degree felony. 19 CF 1659, possession of controlled substance, third-degree felony. 19 CF 1660, drive while license suspended, habitual traffic offender, third-degree felony. 20 CF 835, drive while license suspended, habitual traffic offender, third-degree felony. And 22 CF 1506, which is possession of ammunition by a felon, second-degree felony. Driving while license suspended, habitual traffic offender, third-degree felony, possession of a controlled substance, third-degree felony. Just want to make sure you understand all those third-degree felonies. The maximum is 60 months or 5 years. And then in the one second-degree felony, it would be 15-year maximum. There was a suspended sentence that of 60.1. I think everyone agrees that's the maximum amount I can give you on the violation of probation. Do you understand that?
Yes, sir.
And that was done back in October of '23. All right. Did you go over, and as far as your admission, you're admitting to paragraphs 1 and 2 of the second amended affidavit, which is the two drug test charges, is that right?
Yes, sir.
Okay. But you still want to have an evidentiary hearing on 3, 4, 5, and 6, which are the failure to report, refusal of the drug test, changing your residence or absconding, and then the new law violation. You want to have a hearing on those.
He didn't want to, no, sir, but
Actually, Judge, I think it's the state that
the
wants to have the
state
hearing on
wants,
those.
I don't want to.
Yeah.
I understand. You're not willing to admit to them.
Yes, sir.
So then you'd want an evidentiary hearing in order to have the state prove them.
Yes.
That's what you're saying. Okay. All right. Did you have a chance to go over this form with Mr. Russell?
Yes, sir.
Do you understand it?
Yeah, yes, sir. Yes, sir.
Do you have any more questions about it?
So I will have to have I'm going through an evidentiary hearing, what I was trying to avoid, pretty much.
I understand.
That's what I'm asking.
There's basically you've been charged with violating your probation in 6 different ways. Think of it like you got charged with 6 different crimes. You're willing to plead to 2, and they want to go forward on the other 4.
All right.
Because, I mean, I'm not trying to work out people's strategy here, but my understanding is from the suspended sentence that was given prior to me taking over the case, the maximum I can give you is 60.1 months. I can give you less. I'm assuming the state wants to prove those things to me so that I'm more likely to give you the suspended sentence than do less.
Yes, sir.
So did you have any other questions? All right. Did you go over this form and did you understand it?
Sir.
All right. Did you sign it?
Yes, sir.
Do you need any more time to talk to Mr. Russell, your attorney?
No, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any mental health concerns?
Past
diagnoses?
We have a doctor, but I haven't got back the diagnosis of what he's...
Okay. Well, do you understand what's going on?
Oh, yes,
here
sir. Yes,
today?
sir.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand on the 2 parts that you're admitting that there won't be a hearing on those as to whether or not you've committed the positive UAs? Because you're admitting to those.
Oh, yes, sir.
Okay, but there will be a hearing on the other 4 counts of the second amended affidavit of violation of probation. You understand that?
Yes, sir.
So you're waiving any potential defenses you may have had for the first 2. Do you understand?
Yes, sir.
that? Okay. And are you admitting that you violated in those ways, or are you denying the first 2?
I admit it.
Okay, so you're admitting allegations 1 and 2. I'm going to find your admission is freely, voluntarily, knowingly given. I guess we do March 27th at 2 o'clock for the evidentiary hearing.
May I ask the court? We were able to communicate with Officer Johnson. She would be available next week. So, do you think, Judge, we can set it?
That's the probation officer, right?
Yes, yes.
Mr. Russell, do you want to try and do it next Thursday afternoon?
The only problem with that, Judge, is that we would have witnesses of our own that he wants to bring in.
That's
and
fine.
I don't know if I can get a hold of them that quickly and get them subpoenaed. Mr. Dixon believes we can get a hold of him, Judge. I've been trying, but we can try next week.
So what is that? That's going to be the 13th?
Yes,
February
sir.
13th at, I want to say 1 o'clock, just in case.
I think it would be fine, yes, because if we have a pretrial detention, yes. Thank you, Judge.
Any issue for the clerk that day? Okay, I just want to make sure. So I'll go ahead and make sure we've got a courtroom for that. Shouldn't be a problem. All right, so we'll put the evidentiary hearing on February 13th at 1 o'clock. Obviously, if something comes up, make sure you tell us in advance if that's not going to end up working out.
Yes, sir.
Yes, sir. Thank you.
And the 2024 case will go with it for
Go with
status
it.
purposes.
Yeah.
Thank you, Judge.
All right, thank you, Mr. Dixon. We'll see you next week.
Thank you.
Okay. Here you go. Let me get back to that one. All right, your name, sir?
Donald Paul DeShulo.
DeShulo.
Yes, sir.
Okay. It's just an arraignment. All right, Mr. DeShulo, you're here in 25 CF 27, charged with driver while license suspended with prior conviction. Looks like the public defender's been appointed. Ms. Rivers is from the public defender's office.
Your Honor, we're going to enter a not guilty plea and request trial by jury.
May I put the offer on the record? It would be to plea to a misdemeanor, still third driving on a suspended license, which does carry a mandatory 10 days jail. But it would be a plea to a misdemeanor of that charge with that mandatory 10 days, 300 in court costs, and adjudication of guilt.
Yes, ma'am.
Okay, hang on. Your Honor, my understanding is we have a conflict with this case and we're unable to represent him.
So the only option, Judge, is either he can represent himself and enter the plea if that's what he would like to do, or we can file paperwork and withdraw.
Mr. DeShulo, do you have any other cases?
No, I have one in Walton County. It's a misdemeanor, not failing to register renew my license. I just have to go in front of the judge, first appearance, and then they'll set a court date for me. And I'm sure I'll take care of that.
Is there like a hold for you? Or
Yes, sir.
They're going to transport you over
Yes,
there
sir.
after this?
Yes, sir.
Okay. Do you want to go forward with that plea offer?
Yes, sir.
Do you want to do so without a lawyer?
Yes, sir.
All right. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, so the plea offer that's been provided is plea to a misdemeanor, which is a first-degree misdemeanor. There's a mandatory 10 days in jail. I'm guessing you've already got that in.
Yes, sir.
Okay. And then the court costs were $300. I can give you 90 days to pay that.
And there's also a speeding ticket.
Well, I can't handle the speeding ticket.
Okay, I was going to say, I'll take care of that as well.
That's county court, but
Okay, yes, sir.
you got to go take care of that separately from this.
Yes, sir.
Okay. All right. Do you understand that you don't have a lawyer appointed because I have a conflict? I can get
Yes,
you a
sir.
lawyer, but they're not here today.
No, that's all right.
Okay. All right. Do you feel comfortable going forward without a lauyer?
Yes, sir.
Have you ever represented yourself before?
Yes, sir. I am in the one in Walton.
Okay. Is that one going well for you?
Yes, it
Okay.
is.
All right. And how old are you and how far have you gone in school?
I'm 59 and I got my GED.
Okay. Do you understand that a lawyer could help you as far as look into the case, investigate it, find out if there's other types of defenses that you may have?
Oh, I understand and I'm good.
All right. Are you under the influence of any alcohol, drugs, or
sir.
controlled substances?
No, sir.
Any mental health issues or concerns?
sir.
All right. Has anyone forced you to take this plea?
No,
Has
sir.
anyone promised you anything other than what the plea offer was to get
No,
you to take
sir.
this plea? Do you understand there won't be a trial of any kind?
Sir.
Do you understand that means there's not going to be a jury? You're not going to get a chance to confront and cross-examine the witnesses against you. You're not going to have a chance to call your own witnesses and put on any defenses that you may have.
It's coming here.
And then you're also giving up your right to have a lawyer to represent you at this point.
Yes, sir.
Do you have any concerns about that?
No, I don't.
Okay. What's your plea to the misdemeanor driving while license suspended?
Guilty.
Hold on.
Or no contest?
Hold on. I just want to make sure I finish it.
Yes, sir.
Driving while license suspended, third conviction misdemeanor. Okay. Let me ask you something. You've got others.
Before 2019, I've been pretty good about it, you know.
What my concern is, have you ever been a habitual traffic offender?
No.
Okay. Do you understand that if you get 3 specified traffic offenses, including driving while license suspended,
Yeah.
in a 5-year period, they'll revoke your driver's license for 5 years.
Yes, sir. I'll take care of that right away.
Well, it doesn't, this is going to be one of those kind of predicate offenses towards that.
Yes, sir.
So if you've got another one in Walton County, and you've got another one within the past 5 years, you could, I'm not trying to give you legal advice, I'm just
Right.
trying to make sure you understand that.
Right. I'm good.
You understand that?
Yes, sir.
Okay. All right, and you said no contest?
Yeah.
All right, I'll accept your no contest plea to the misdemeanor driving license suspended is freely, voluntarily, knowingly given, 10 days county jail, which is mandatory adjudication of guilt, $300 in court costs. I'll give you 90 days from your release from jail. Okay, to go set up a payment plan or pay that with the clerk's office here in Okaloosa County.
Yes, will do.
All right, any questions?
No, sir. Can the courts notify Walton County that I've satisfied Okaloosa?
Well, basically, the jail's going to say you're released on our case. If
Yeah,
Walton
okay.
has a hold.
Yeah.
Will
They'll
they bring the
notify.
first appearance tomorrow for that? I don't think, they might bring you to first appearance tomorrow.
Okay.
If they do, the judge tomorrow will tell you, Walton's going to come pick you up.
There is. Yeah.
Appearance.
Sure. All right. Thank you very much.
All right, might not be till next week. Just because tomorrow's Friday, I can't
Yes,
tell you
sir.
for sure. All right, thank you, Mr. Say it again.
DeShulo.
DeShulo.
Yes, sir.
All right.
And thank the state.
Oh, I need your fingerprints. It's a misdemeanor, but it's a driving while license suspended. I need your fingerprints, then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge.
All right, thank you, sir. DeShulo. All right. Sure. Well, I'm not sure how quick Gormley's going to be after this morning. Okay. Okay. And Horn. All right. Okay, why don't we handle that? Mr. Napoleon? All right, this is 24 CF 809. Mr. Williams, I think Mr. Napoleon is yours.
Sure, what's your name?
William Napoleon.
Napoleon, okay. Mr. Napoleon, I tried to call you twice yesterday.
This is the motion to compel disclosure of DNA.
Right, I had conversations with the state about this case that I was trying to pass along. One, it looks like we may have a resolution on it.
Okay. All right, take a seat, Mr. Napoleon. We'll call you back up. So we've got Mr. Gormley, we've got Holly, we've got Horn.
Yes, sir.
I missed one?
Tatum.
Tatum.
Sir?
You want Tatum? Bring Tatum.
With that information, do you know what you want to do, sir?
Yeah, could we please address, before bringing out anybody, the issue you want to talk to me or?
About the new information on Horn?
Yes.
I'm still going to have to, make him aware of it. But basically, the state's advised me that there's some additional evidence that hasn't been provided so far. The most significant, well, both of it may be, of the items may be significant. One in particular, though, is the actual department policy on the flock device. If the court will recall my motion, I did not have the actual department policy, but I cited what the basically the user agreement requires, and that that FHP would have had to adopt that policy. But I just received this information about 5 minutes ago.
Okay. So is he in custody?
He is in custody, Judge.
So what are y'all wanting to do?
I'm ready to go forward. I can show the documents right now to defense. I haven't even seen them, Your Honor, but I did talk with Trooper Avery. Now,
I don't know that it's going to make a huge difference because the underlying charge is trafficking. So in terms of what Mr. Horn's going to want to do, whether or not he wants to create a record potentially on appeal, he's probably going to want to do that. I just don't know.
All right, it sounds like we've got talking that has to be done about pretty much every case we've got left. Unless, Ms. Rivers, you're ready with Tatum.
We're ready with
Why don't we take Tatum with Ms. Rivers and Mr. Williams and Ms. Leone? Y'all can talk about what you want to do.
It's hers.
Judge, with regard to Mr. Napoleon, Mr. Napoleon wants to accept the state's amended offer, which is education and time served.
All right.
He just wanted to know what the change in the score sheet would be, and I just gave him a quick and dirty answer.
The reason why I brought it up is because if we're not going to go forward with Mr. Horn's motion to suppress, I can release Trooper
I understand, but
Avery.
y'all are having conversations I don't necessarily need to be a part of.
Yes, sir.
Because you're talking about evidence, and unless we're having a hearing, I don't really want to have y'all doing that in the well. If we can handle other things while you're talking about that. But it sounds like everything involves at least one of you. All right, do you want to handle Tatum while he's talking to
That
the
would be
trooper?
fine, yeah.
All right, Tatum.
Go local. Yeah, but after this many years. Your friend said he did. What is it? What is my thing?
This is going to be Tony Tatum, who's present, 20 CF 1826 and 20 CF 2406. I believe we're here for an evidentiary hearing.
Yes, Your Honor.
Is everybody on the same page as to what document this is based off of, as far as the affidavit? Is it the one from
think so.
October 7th? There's allegations of a new arrest battery, new arrest obstruction of justice, and failure to remain confined to an approved residence. Are those the three things we're going forward on today?
Yes, Your Honor.
State ready to proceed?
Yes, I just need 1 second to open the file, Your Honor.
Are you ready, Ms. Rivers?
Yes, Your Honor.
Okay, the state is ready, Your Honor. Would you like me to call the first person?
Does y'all want to put anything on the record as far, was there a plea offer extended?
We can, Your Honor. We went back and forth on the timing. Ms. Rivers, could you please remind me what was the last one?
Just so Mr. Tatum knows what's been conveyed.
Yes.
Your Honor, at first, the state offered 50 months DOC. Then we were able to get it down to 40,
I think 44, you're right.
44 months DOC, and now there's not enough for now.
And what is the maximum that he could be looking at?
I believe it's 20 years, Your Honor.
25 total with the new law and everything. Just on the VOP would be 20, right?
Well, are the new laws here, or it's
It
battery
is.
and obstruction, so I assumed it was in county court.
No, it's a second on battery, so it's a felony, yeah.
Okay, and it's been filed that way?
Yes, Your Honor.
Okay. So just on the VOPs, which is what the hearing's on today, it's 20?
Yes, the 20 CF 1826 and 20 CF 2406. So to clarify, Your Honor, about the score sheet, the 53.7 months are inclusive only of the VOP cases and the VOP points that do not include the new law. So obviously, when you include the new law, the VOP points will increase, and it's going to be a little bit extra time for minimum guidelines.
Shown is it burglary of an occupied structure? 1826?
Yes.
Okay, so that's potentially 15, and then he's got 3 third-degree felonies in the other case?
I have to, Your Honor, correct myself. It's 25 years only the VOP charges.
There's 2 hold on. 2 more misdemeanors as well, but, all right, so Mr. Tatum, I'm not trying to indicate in any way what I would do if you're found to have violated your probation. I just want to make sure you understand what their plea offer was, that it was conveyed, and what the maximum amount of time that you could actually be sentenced to if you go forward with the evidentiary hearing. That you could get as much as 25 years in DOC if you're found to have violated your probation. Again, not an indication as to what I will sentence you to if you're found to have violated your probation. I have to make sure you understand the maximum. Do you understand that?
Yes, sir. Well, the only plea offer they had for me was 53 months. And then I was telling her, like, what I was on probation for was just a burglary and
burglary,
yeah,
felony battery,
yeah.
intimidating a witness.
Yeah, that was the only, all the misdemeanor stuff was terminated.
That's already terminated.
Okay.
That's why I talked about just the felonies.
Yeah, then she said when she did that, the point came back to 33 months. Okay, I told her I would have signed them 33 months, but she told me.
Is there a score sheet for 33 months?
No, Your Honor, the score sheet.
I just want to make sure it's all on the record.
The score sheet that was originally provided by the state included the new law and the VOPs. And it originally came out to around 50 months. Then we had a discussion back and forth, and based on the way the state had done the VOP points, a technical only would have made it from 30 to 33. However, I had conveyed to him that I had gotten her down to 44 months. Then, after he rejected that offer, I went back to the state, informed her that he rejected that offer. The state then sent a new score sheet, and on the new score sheet, she scored him as a habitual felony offender and changed the violation of probation points to where it's 12 each time. This is the third alleged violation, and so now it bumps him back up to basically what his new law, if his new law had been.
Sixes.
Yes.
Yeah.
What do we believe the current score sheet for the VOPs is?
This, the 53.7 months.
63?
53, 53, Your Honor, yes.
Anything else that y'all want to put on the record?
No,
I will.
Hold on, Mr. Tatum, raise your right hand if you're going to say anything. Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Do you want to speak with Ms. Rivers, your attorney, before you say anything else?
Yeah, I just want to ask, like, how can I be $15? They told me I had to be convicted of 3 last time. Yeah, I ain't convicted of that.
So because it's an F2, the burglary isn't actually F2, the score sheet said that charge, she can do the VOP points that way. And that's why I included that paperwork when I gave you that, to show where it says that she could charge it that way.
Really, I'm just gonna get charged and everything without. I'm gonna get sentenced and everything without even being convicted of my.
That be convicted of the new law, correct?
Yeah, so y'all going off of so-called convicted of the new law thing.
No, and again, it's because she changed the score sheet. Before, she was giving you a break by not charging you as a habitual.
Anything else, Ms. Rivers?
Sorry, Your Honor?
Anything, Ms. Rivers?
No, Your
Mr. Tatum? All right, we ready to proceed?
Yes, Your Honor, the state calls Officer Culberson from Crestview Police Department.
Come on up, officer. You raise your right hand. You swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth. Take a seat. Make sure you speak into that microphone for us. Go ahead with your question, Ms. Leone.
Yes, Your Honor. State your name for the record.
Tyler Culbertson,
Where are you employed?
Crestview Police Department,
How long have you been so employed?
coming up on 4 years.
Please explain what your training and experience entails.
I've had police academy, I've been to canine handler school, CIT training, as of now, interview and interrogations,
Do you have any specialized training?
beyond canine, no ma'am.
Were you on duty on August 19, 2024?
Yes ma'am.
What were your duties then?
That night I was a canine handler for my shift,
And what was your shift time?
6 p.m. to 6 a.m. That night was a little bit different, as the city had a mandated meeting that we had to have for the entire department, at which time the sheriff's office was covering our calls till about 8 p.m.
On August 19, 2024, did there come a time while you were on duty that you became involved in an investigation regarding a person that later became known to you as Tony Tatum?
Yes ma'am.
And do you see him in court today?
Yes ma'am.
Can you point to him and identify by an article of clothing he's wearing?
He's wearing orange DOC jumpsuit.
Thank you. Let the record reflect that the witness has identified the defendant.
Reflect.
So please explain how you became involved in this investigation, in this incident.
Yes, ma'am. As the mandatory meeting I previously mentioned came to a conclusion, I switched out of my Class A, as I'm wearing today, to my patrol uniform and went out and started taking calls that were holding. That call was a disturbance. I ended up putting myself en route and went down there due to the rest of my shift being occupied on other calls.
Prior to arriving on scene, what information did you gather from dispatch or other officers?
Dispatch had informed me of the call holding. I believe they told me the sheriff's office had been on scene for give or take 30 minutes or so, doing the initial receiving of information, and I was en route to relieve them and take over the investigation.
And could you please state what address did you respond to?
180 Cracker Barrel Drive. Then it was the Juicy Crab restaurant.
Is that in Crestview,
Yes, ma'am.
Okaloosa County?
Yes, ma'am.
Do you remember approximately what time it was when you responded?
I know it was, I believe it was before 8:30 p.m., somewhere between 8 and 8:30 p.m.
And when you responded, did you meet any witness?
I didn't meet any of the witnesses initially when I responded. I was able to speak with one witness throughout the investigation later that night at another location.
And please tell the court what that witness told you.
I'm going to refer to my report so I don't mess it up. That witness was Mr. Eric Woods. He completed his sworn witness statement regarding what he saw, at which point he said they, speaking about the alleged victim, and Mr. Tatum speaking loudly at the Tom Thumb at 4051 South Verdon Boulevard. She had asked him for her phone. He walked away. She told him to give her the phone. He then went behind the store while she went around the front of the store and told Tony he was going to get in trouble. She asked for the phone again. At that point, Mr. Woods lost visual, didn't have any further. When she came back by, she said he put his hands on her and she called the police.
Did the whole investigation entail speaking with other eyewitnesses?
I was able to speak with one of the employees of Juicy Crab that was not on scene, or I was not able to speak with her the night of the incident. I followed up with her, I believe it was the following day, on the 20th of August.
And did you get a chance to speak with the victim?
I did speak with the victim, yes ma'am.
Where were you when you spoke with her?
I was at the Juicy Crab on the night of the incident.
Do you remember what she told you?
I'll refer to my report. She explained to me that they had gotten to an argument. She had driven both of them to the restaurant. Once they were there, she was informed by Mr. Tatum he would not be paying for the meal, as she previously understood the arrangement was to be. At the time they started arguing, initially the argument was verbal only inside the restaurant. As it continued, the victim went to leave the restaurant, at which point Mr. Tony followed her to her car. Due to tension, she didn't wish to give him a ride home from the restaurant. When she informed him of this, he got into her car anyways. She went back inside. He again followed. And with Tony repeatedly ignoring her wishes to leave, she began to worry and fear for what he would do. For this reason, she told him she was going to call the police because he would not leave her alone. He allegedly became upset and snatched the phone out of her hand, catching her hair in the process. When that happened, he then went outside and refused to give the phone back. He then fled the restaurant on foot, ran along Cracker Barrel Drive to South Verdon Boulevard until ultimately reaching John King Road.
Based on your, how would you describe the victim's demeanor and behavior at the time of your interview with her?
She was rather worked up. She seemed frustrated by the incident.
Do you know if anybody called 911 that night in regards to this incident?
My understanding is there were several 911 callers that called into the sheriff's office. As far as who they were, most of them had left prior to my arrival due to the 30-minute time lapse. I believe staff had called, and I was able to speak with one of the staff members. I don't know if she is the one that called, but I was able to speak with one of the staff members that were present that night.
Your Honor, I have the 911 calls. Defense is not objecting. May I move it into evidence?
I do want to consult with my client, Your Honor. Your Honor, my client doesn't see the point in the 911 calls. We would object at this time. It's not like we could cross-examine whoever these unknown people are on the 911 calls.
Your Honor, the state obviously states that, first of all, it's a 911 call. There is a certificate of authenticity when it comes to authentication. As far as the statements inside the 911 call, there are at least two different speakers in the 911 call. One is the victim. The other one is the employee of the restaurant who was witnessing the incident and was calling 911. So I would make an argument that it comes under either excited utterance or present sense impression. So it's an exception to hearsay, and it should come in.
It's a VOP, hearsay is admissible, it just can't
Yes.
be the.
And
sole
in addition to
purpose
that,
or
Your Honor,
reason.
I think it's also my intention, in one of the calls, the one played by the victim, you can hear the defendant's voice in the background, so.
All right, so what's your objection, Ms. Rivers?
Your Honor, well, I would object at this point to any proffered testimony by the state that it is my client in the 911 call. I believe that they would have to establish his voice and that she's familiar with his voice to be able to have anyone testify that it's him on the 911 call. But I do agree.
Oh, I'm not taking Ms. Leone's comments on the evidence as testimony or evidence itself.
But I do acknowledge, Your Honor, that VOPs, you are allowed to have hearsay. Can't be all hearsay, but you can have hearsay.
Well, Your Honor, I would like.
What is there an objection to the admissibility of the 911 call?
No, Your Honor.
Okay.
And I would ask the court to allow it as non-hearsay.
Well, I think I'd have to hear it in order to
Okay.
know if it's not hearsay. You've told me it could be potential present sense impression or excited utterance, but I haven't heard it to be able to understand that yet.
There you go. May I publish?
Yes.
And I'll move it.
And once I listen to it, I'll make rulings on those things, Ms. Rivers.
Very well, Your Honor.
I can't really make a decision until I get to hear it.
I'm not sure if I need.
Oh, your laptops.
I don't know. Doesn't matter. It's not going.
I've got it on Council 2 laptop. What's that?
You may have to choose your output device.
Or since it's only audio, if we just want to put a microphone on the speaker. I'm fine with it as long as I can hear it.
I don't know. Where's my speaker output on this thing?
Generally down here or up here.
I don't know.
Do you want me to do it?
I need a police officer. Okay, hold on 1 second for me.
Can you hear it?
Well, that junk ass shit. Now you gonna get yourself in trouble. Are you doing stupid shit? Christy County, I got a caller at 180 Cracker Barrel Drive requesting law enforcement. Yes, I need a police officer.
You hear that?
I can hear it. Y'all hear it?
Yeah, I'll try with my computer.
trying to. Chris trying.
I am playing through the court.
Course volume's up, and I already turned the table up. Table 2 is up all the way too. That's 2, right? This is 1. Why don't you try the Blu-ray player and see if that'll work? What kind of file is it?
It's audio file.
Wave.
Wave.
WAV.
That may work.
That's right. No, I'm saying if you wanted me
I've
to.
already switched to the Blu-ray player.
Oh.
Oh, so you want the disc?
Yes.
Oh, okay, Judge. I didn't understand. Here you go.
Door's not even opening. Let's see this one. Or is that one?
This thing? Yeah? What do you think? Should I try?
I don't think that's gonna work. You get an IT. Yeah. I'd like to just, I would like to just put it in there, but I know I might get my hand slapped for that. It's not opening. What are you plugging that into?
My computer?
That's not doing anything. Here.
Oh. Well, maybe it's this thing that is not working.
This before.
Yeah.
911, what's your emergency? I need a police officer at 55. Okay, hold on 1 second for me. Bro, that drunk ass shit, now you can get yourself in trouble. And you doing stupid shit. County, you gotta call it 180 Cracker Barrel Drive, requesting law enforcement. Yes, I need a police officer.
Opera, was that it?
It stops and there are a few more excerpts from the same call. It's just the way they record it.
You want to see dispatch? I got a call at 180 Cracker Barrel Drive, requesting law enforcement. Alright, I need a phone call. Alright, what's going on? Can y'all please come on? Okay, well, I need to know what's going on first. Can y'all please come on, please? Okay, what is going on at 180 Cracker Barrel Drive? I can send somebody, but I need to know. Hello?
Yeah, this is Okaloosa County 911. You have a call from this number. Is everything okay?
Yeah, I think that I work at JC Crab, like Cracker Barrel Road. He had a couple customers. The guy like pushed the girl around her phone, and they like went running, and they're over here by this gas station. I'm not sure.
What gas station?
What is it? I'm not really from here. It's the gas station right on the side of Cracker Barrel Road.
Hey, this is like this. There was a party event, and I've got the caller on the line. We possibly associated with that disturbance we're going through out there.
Okay, yeah, it's the Exxon.
1 second, ma'am. Christy?
Yeah. I don't see any.
Ma'am, hold on 1 second. Let me talk to Christy PD. 1 second. Go ahead, Christy.
That call, we got one together, fill out some questions, you get more information. Good.
Okay. You said that the gas station down there?
They were like 2 minutes ago. I had to go back inside to work. I don't hear them anymore.
What, 2 minutes ago?
Screaming.
You can't hear screaming?
Yeah, they're like right in the area. I think they're in the other gas station now. He's wearing a white shirt, if that helps, but he's kind of...
Yeah, blackmail, second one.
Blackmail.
Can you feel him now?
I believe so, but it's kind of hard, it's just a fit. But like I said, I can hear screaming a little bit in the background.
But you can still see them?
I believe that's them, yeah. But I don't even know. It's great. Oh, there's a sign that says TV by Lindy's Whataburger. They're in that area. I mean, they were running. They're like facing each other. And,
Did you see any weapons?
no, I didn't see any weapons.
What is your name?
My name is Emily.
What's your last name, Emily? And you said you're an employee of DC Quick Crowd?
Yeah.
What's your phone number? Can you still see me?
No, and I kind of got to run into work. I mean, it's been a couple minutes. I'm surprised no one else has called.
Yeah, they have.
Okay, yeah, it won't be hard to spot them. I mean, they're noticeable.
Okay, we're getting them out there, okay?
All right, thank
Do
you.
you want contact with the deputy or you just want to report it?
I just really wanted to report it. I mean, if you did contact from me later, that's cool, but yeah.
Okay.
All right, thank you. Old Barrel Road.
Hey, this is there was a property abandoned, I've got the caller on the line, we possibly associated with that disturbance we're going through out there.
Okay, yeah, it's the Edcon.
1 second, ma'am, Christy.
Yeah. I don't see any.
Ma'am, hold on 1 second, let me talk to Christy PD, 1 second. Go ahead, Christy. Okay, you said at the gas station now, ma'am?
They were like 2 minutes ago. I had to go back inside to work. I don't hear them anymore.
What, 2 minutes ago?
3 minutes.
You can't hear screaming?
Yeah, they're like right in the area. I think they're in the other gas station now. He's wearing a white shirt, if that helps, but he's kind of...
Yeah, right now, second one.
Black nails.
Can you feel now?
I believe so, but it's kind of hard, it's just a bit. But like I said, I can hear screaming a little bit in the background.
But you can't still see them?
I believe that's them, yeah. But I don't even know. It's right, there's a sign that says QB by Wendy's, Whataburger. They're in that area. I mean, they were running, they're like facing each other, and,
You see any weapons?
no, I didn't see any weapons.
What is your name? You said they're an employee of Judicial crowd?
Yeah.
What's your phone number? Can you still see me?
No, and I kind of got to run into work. I mean, it's been a couple minutes. I'm surprised someone else just called.
Yeah, they have.
I'm sorry, Your Honor.
I think we've heard this part already.
It's the way they cut it. I'll go to the next one.
911, what's the address of your emergency? I need Dr. Tony Tatum. Do you need police? Let me out the hand. Yes, I want to press charge. Okay, ma'am, tell me what's going on. He put his hand on me. What is your address? I made him come down. That's just number one. Okay. And so tell me exactly what happened. I was at Duty Cloud, and he's been drinking, and he pulling my hair and stuff. You said he was pulling your hair or pulling your hand, but I didn't hear that. Pulling my hair. Okay, and what is your name? I want that charges. Man, what is your name? Okay, I'm gonna get someone to you, but I need your name. My name is... Okay, stay on the line with me. All right. Hey, it's Okaloosa. I have a caller on the line that needs to report a disturbance that just occurred over at Tom 4051 South Boulevard. Are you needing us to respond to it? Then I'll press the fucking shot. Fuck him. Ma'am, did this start at Juicy Crab? Yes, it did. When he picked all around.
Yeah, y'all judge, you know, just,
Okay, all right, thanks. Okay. Ma'am, are you still there?
The last one, Your Honor.
What's the address of your emergency? I need Dr. Ponytail. Do you need police money? Yes, I have the hand. Yes, I want to press charge. Okay, ma'am, tell me what's going on. He put his hand on me. What is your address? I'm at the Silver. That's just number one. Okay. And so tell me exactly what happened. I was at Juicy Crab, and he's been drinking, and he pulling my hair and stuff. You said he was pulling your hair or pulling your hands? I didn't hear that. Pulling my hair. Okay. And what is your name? I want press charges.
You have the disc for entry into the court's record.
I move.
Ms. Rivers, did you have any other objections now that we've all heard it? No.
I move State Exhibit 1 into evidence.
Yes. Any objection?
No, Your Honor.
All right. You just give it to the clerk. It's fine. You have more questions for
Yes, Your Honor, I'm locating my questions because I had to switch and now I can find it. Um, so on the date of this incident, did you encounter the defendant?
No, ma'am.
When did you ever encounter the defendant?
I was able to speak with him at his residence on August 23rd.
That was approximately about 3 months after?
No, ma'am. About 3 days after, 3 to 4 days.
Oh, you said August. I'm sorry. Yes. And you said that at his residence?
Yes,
Did you speak with him?
I did.
What did he tell you?
Initially, he told me nothing happened. I believe he made mention of an argument over buying dinner, and then he began to walk away. I explained just as he was walking that I would like to ask him questions, but I'd have to read him his rights. He thought that meant that he was going to jail. I explained that it would not. He would not be going to jail that night. He then came back towards me. I read him his rights. After reading him his Miranda rights, he said he would like to speak with a lawyer, at which point I left.
Prior to asking to speak with a lawyer, did he tell you something about the incident?
He repeatedly said nothing happened, and I believe he made mention of they had an argument over him not paying for dinner, but didn't go much further into that.
Were you wearing a body camera at the time you interviewed the defendant?
Yes, ma'am.
And, Your Honor, this time, State moves State Exhibit 2 into evidence. Is Officer Culbertson body camera of the interview with the defendant about 5 minutes long?
Objections?
No, Your Honor.
Permission to publish?
So it would be admitted as States 2.
Yes, please, Your Honor.
Admitted as States 2. No objection.
I think I need to select, or I drag it over there.
Oh, it's video.
Drag it. My question though, how do I,
Push the little square button up towards the upper right.
no, I don't, okay. Oh, you can do it like that, okay. Yes, oh, okay, I got it, I just have to do it like that. Oh, you're right, maybe.
This is going to be the 1 minute prior to activation of the camera.
Is that what it is?
Correct.
Okay, okay, thank you.
How y'all doing tonight? All right. I just need to talk with something to Tatum. Being in trouble right now, I just got to follow up with the incident that we had with LaMarsha. We all know how drama goes. So, I'm just trying to get his side of things, because we made some allegations against him, so I just need to get his side. Okay. He ain't going anywhere, he ain't going to jail or anything like that. I'm just trying to get his side. Yeah. I got it there. So the turkey dog. Sounds happy. Do what? I just got to get a big sandwich of that. Come on, young man. I'm getting out of my eye there. Hold on. Hey, Tony. Call me. I got called over to you about juice and crab the other night. You give me your side of things. I got like 19 people that called 911 and the sheriff's office that responded and said something did happen. So I just need to know what happened. So why the police get called back? I don't know. Alright. Can you walk me through the events of the night? She told me listen, I want you to understand something. She told me exactly what happened, and I've got witnesses. I would like to get your side of it before I end up having to write a warrant, because right now I only have one side of this. I would like your side before I end up having to write a warrant. But I ain't that to happen. Like, we were just talking to ain't that to happen. She just got mad with people up. So, well, let me ask you this. I have some specific questions I'd like to ask you. I'm going to use your rights, because she made allegations, so I have to before I can ask any questions. Is that okay? Yeah, okay. Yeah? You want to talk with me for a few minutes, sir?
If I may, I don't believe there is any other statement made after this, officer?
He walks back over in just a couple moments, and I am able to read him his rights, at which point he lawyered up.
Okay. Would the court like to see it, or?
I mean, it's evidence, it's been admitted, I think I have to see.
Sure. Yes.
Okay, they come out and lay allegations, but if you tell them, can I just stop you, man? No, I'm telling you, she told us, she know that person, there's at the okay, can I ask you a couple questions? So you gotta ask the question, I ask the question. Okay. I gotta read your rights first, that's policy, man. It don't mean you're going to jail, and I'll tell you right now, you're not going to jail. If you read my rights, tell me, I'm not leaving with you today, I just have to ask questions. Okay. Alright, you have the right to remain silent. Anything you say cannot be used against you in court of law. You have the right to talk to a lawyer and have him or present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any question. If you wish, you can decide at any time to exercise these rights and not answer any questions about getting statements. You understand each of these rights? You mind answering a couple questions? I get the lawyer. You what? I get the lawyer. Alright, that's all right. That's your right. I'm gonna get out of here. Have a good rest of your night. Thank you, sir. Warning it is.
I don't have any other questions for Officer Culbertson. May I approach Madam Clerk?
That's exhibit 2.
You got anything for me to ask?
Say you came and contacted me.
Culbertson, yes, ma'am.
Culbertson? Okay. Officer Culbertson, do you know Tony Tatum?
Aside from seeing him at work, no, ma'am.
Did you, you identified Tony Tatum here today in the courtroom, correct?
Yes, ma'am.
Did you see him at the Juicy Crab on the night in question?
No, ma'am.
All right. You said you went to Juicy Crab that night, correct?
Yeah, on the night in question, yes, ma'am.
Yes. And did you witness any disturbance?
No, ma'am. As I previously stated, that was, the disturbance occurred about 30 minutes prior to my arrival.
Right. So everything that you've told us here today is what someone else has told you, correct?
Yes, ma'am.
All right. And LaPortia Baker, do you see her in the courtroom here today?
I do not, ma'am.
That's all I have.
Redirect.
Oh, yeah.
Need Officer Culbertson to stick around.
No, he doesn't have to. He's released.
Ms. Rivers?
Yes,
Any issue with him leaving?
No, Your
All right, you're free to go. You're free to stay as well, but you won't be.
Thank you, sir.
All right, other witnesses?
Yes, Probation Officer Erin Galogli.
Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And take a seat.
State your name for the record.
Erin Galogli,
Where are you employed?
Department of Corrections.
What are your duties?
I am a probation senior officer,
How long have you been so employed?
approximately 8 years.
As a part of your employment, do you supervise people placed on probation?
Yes, ma'am.
Do you supervise the defendant here in the courtroom, Tony Tatum?
Yes, ma'am.
When did you begin supervising him?
I don't know how the exact date here. June 18th of 2024, I believe.
As the probation supervisor for this defendant, do you have care, custody, and control of the file pertaining to that supervision?
Yes.
And when did you establish their file or took over their file? I know there might have been other probation officers supervising him before.
Yes, ma'am. I believe June 18th of 2024.
And could you tell the court the case numbers that are assigned to that file?
Yes, ma'am. 2020 CF 1826 and 2020 CF 2406.
Does, are notations, records, and documents in that file are filled out or completed at the time or shortly after that information is obtained?
Yes.
And do you or a member of your department fill out that information?
Yes.
And you have a legal duty to do so?
Yes.
Per your,
Yes.
and all the materials pertaining to this defendant are contained in the department's file?
Yes.
And you have a case log?
Yes.
Does your file indicate the original, when Mr. Tatum was originally placed on probation?
I have that he was placed on probation February 14th of 2023 and then modified due to a violation on June 18th of 2024.
And for what charges was the defendant placed on probation originally?
Yes, ma'am. It was burglary of an occupied structure, tampering and misdemeanor proceeding, felony battery, and DUI.
And does your file indicate that the defendant was advised of the responsibilities and duties of probation?
Yes.
And did you personally advise him of those duties and responsibilities?
So the forms that are here, because this originated in Fort Walton Beach, the officer there had him sign them, but I always go over it myself, and I've previously had him on these same cases before this violation as well. So, yes, ma'am.
May I approach the witness? I'm showing you what's been pre-marked, the State's Exhibit 3.
Yes, ma'am.
And what is that?
That is a violation report that I submitted.
Completed and signed by you?
Actually, it looks like it had corrections on it, and someone else signed it for me. But I typed it and completed it.
Yeah, State moves State Exhibit 3 to evidence.
It's someone else signed it?
Yes, ma'am. If for some reason we're not there, even though we did the report ourselves, if there was any corrections or anything made to it, someone else can sign it for us and attest that it's for us. That's common, actually, very common. So Otis Brown signed it for me, the one that was e-filed to the court. I did prepare the document, though. Sorry, go ahead.
Your Honor, as long as she's testifying that she has signed a document and this is just a subsequent one and that she recognizes Officer Brown's signature, then I
Yes.
have no objection.
Is that what you're saying, ma'am?
Yes, Your Honor.
Okay, so there's no objection. All right, 3 will be admitted.
Thank you, Your Honor. Should I give it to Madam Clerk?
Let me see that because I haven't seen what it is.
She filled it out.
Yeah, David. Your Honor, may I approach the witness with State Exhibit 4?
Yes.
Thank you. I've shown it to the defense already. What's been pre-marked as State Exhibit 4, do you recognize this?
Yes.
And what is that?
This is the affidavit for violation of probation.
And it states the grounds for violating Mr. Tatum.
Yes, the new charge for obstructing justice, battery, and failure to remain confined to his approved residence. And I believe the reason for the correction was one of the case numbers was left off the original document that I had signed. So they had to correct that to make sure that all the case numbers were on there. And I wasn't there when they corrected it, so.
Evidence?
And Your Honor, we would object since, again, this is something that my client and I have discussed it, and since this is something that she has not signed, this is, she's asking the court to accept a document from some other person, so we're going to object. It's hearsay.
Let me take a look at it, just so I... What is the state attempting to prove with this document?
I'm just making it part of the evidence, Your Honor. It's the affidavit based on which the defendant is being violated. It's being filed with the court by probation, just for clarity of the record.
It's already been filed as part of the court file, so I'm going to admit it over objection. And the court can take a look at its own files.
Could you please tell the court some of the requirements that the defendant had according to his probation period?
Yes, ma'am. There's 14 standard conditions that everyone has when they're on supervision. Report is directed, remain in a specific place, don't change your residence. That just means don't move. Do not possess or carry any firearm or weapon, live without violating any law. A conviction in court of law is not necessary for such a violation or law to constitute a violation of probation, community control, or any other form of court-ordered supervision. Do not associate with any person engaged in criminal activity. Do not use intoxicants to excess or possess drugs or narcotics without a prescription. Work diligently in a lawful occupation. Promptly and truthfully answer all inquiries directed to you. Pay restitution court costs. Submit to random drug testing. Submit to DNA sample. Take a photograph for the department, report in person within 72 hours of release of incarceration. He had some special conditions that were to have a drug and alcohol evaluation within 30 days, start any treatment within 60. Restitution was held to be determined for 120 days by the court. Submit to random drug testing, successfully complete 100 hours of community service work, no contacts with Kira Morris, successfully complete batter's intervention program, DUI school, victim impact, 10-day vehicle impound, 6 months driver license suspended, and then he violated that and was modified on the same term, which added the community control conditions, which is you will report to the officer at least one time weekly. You will remain confined to your approved residence except for 1/2 hour before and after your approved employment, public service work, or any other special activities approved by your officer. Maintain an hourly accountability of all of your activities on a log, and submit to your officer upon request, and then the fees.
You said that he was reinstated and the probation modified to community control.
Yes, ma'am.
Did the defendant work at the time that he committed this crime?
Yes, ma'am.
Objection that he allegedly committed?
I withdraw that. I didn't say allegedly. So, I guess, did he have permission to go to work?
Yes, ma'am, he did.
And what were the work hours that he had permission?
He had permission based on the schedule that he submitted to myself in the office. He was to leave for work at 5 a.m. and he was returned to work at 5 p.m.
From work?
From work, I'm sorry. He was returned home. Be home at 5 p.m. Yes, ma'am.
Have you ever had a chance to go visit him at his residence?
At his residence, yes.
And what are the violations that you are alleging in your affidavit?
What are the, I'm sorry, can you repeat the question?
Yeah, what violation are you alleging?
The new law violations that he was arrested for, and the fact that, based on the police report, he was away from his residence without permission.
On the time of the incident, did he reach out to you to seek permission to go to the restaurant?
No, ma'am, he did not. I actually had a text from him at 5:19 that said he was home from work for the day, and I had nothing else that day.
So the same day that he left, he had sent you a message confirming that he was going to stay home? He was
home?
returned?
Yes, ma'am, he was home, yes.
Did he have an obligation? Why did he send you that text message?
Because he doesn't work for like a brick and mortar place, kind of like Burger King or something, his schedule is constantly changing where he's at. So he is supposed to update me throughout the day of the job sites that he's at. And then because his schedule said 5 o'clock, if he was going to be home after 5, he had to notify me of that. That's why the text was at 5:19 saying that he got home 19 minutes late.
Do you remember the time alleged for the incident to have occurred at Juicy Crab?
If I can refer to my... It was 1953 hours.
So it's like what, 7:53,
Yes,
almost
ma'am,
8
I believe.
p.m.?
Yes.
He never asked you permission prior to that time to be able to go to the restaurant?
No, ma'am.
How did you become aware that he was at the restaurant?
He was picked up on the outstanding warrant, and when I got the police report, that's where I became aware that he was away from his residence at that time.
Since the defendant was first placed on probation, do you remember how many times he has violated the terms?
On this term or the previous ones he's been
From the
revoked
beginning,
on?
from
the
the
very
beginning.
beginning? Oh, gosh, that would take me a minute. Because he's been revoked and reinstated.
So you did testify that one of the violations was for a DUI conviction?
Yes, ma'am. I believe so. Just a second. As you can see, there's quite a few here, so. That would have been in the criminal traffic case on February 14th of 2023.
Yes, that, and what's that date when he got reinstated? First violation.
Actually, his probation was terminated at that point, and then he got a new term, I believe.
New term.
Yes, ma'am.
Yeah, I said modified,
Started over.
meaning, you're correct.
Yes, ma'am, sorry.
I'm sorry. After he got reinstated on 2/14/2023, was there a second VOP violation for DWLSR?
I believe there was, because it's in front of that. Yes, ma'am. That one was for March 6, 2024, is when he got arrested for the new arrest of DWLSR.
And then what happened? He got reinstated or a new term?
On that one, trying to find the exact minute sheet, but based on the order that came after it, it looks like he was. It looks like he was reinstated.
And what was the date of reinstatement?
That was
June 18?
6/18/2024, I believe.
Yeah, it's part of the court record.
Yes, ma'am.
And when did you file for the third violation, the date?
That was on October 7th of 2024.
What are your recommendations for the violation of probation?
My recommendation was that he's not amenable to any type of supervision based on him continuing to break the law, and that he should be revoked and serve a period of incarceration based on the sentencing guidelines score sheet.
Have you tried to coach the defendant and help him out in respecting the terms of probation?
Yes.
And could you give some examples of what you've done to help him?
There were a few times where he reported late. There were a couple of times where I had to call him and remind him to report. There are several times where I had to reach out to him to remind him that he had to communicate with me every day on where he was and when he was coming home. So I was in constant communication to try to make sure that he was complying and that I knew where he was and that he was following the terms of his supervision.
Thank you. No other questions?
Yes, ma'am.
You had indicated that he was, what were you saying again, a half hour before and a half hour after employment?
Yes,
He
ma'am.
has that time period, to get from to the employment? Is that the general understanding?
Yes, ma'am. The general understanding is if you started work at 6, obviously you're not going to leave at your house at 6. You can leave at least a half hour before. He worked a little further away, so he even had more of a grace period, but that's why his schedule said he'd be home at 5, because he really got off work at like 3:30 usually.
And on this date in question, where you said you received a text from him at 5:19 saying that he was at home, did you go to his house on that day?
No, ma'am.
And do you have any evidence that he committed this crime that we're hearing about today, other than what you're reading from a police report?
No, ma'am.
That's all the questions I have.
Any redirect, Ms. Leone?
No, you don't.
Thank you.
No, just argument.
Rivers?
Your Honor.
Any witnesses?
As to what happened,
yeah.
I can say something.
She gets to cross-examine you, she gets to question you. No, Your Honor.
Yeah, if I may I call the defendant to testify?
All right. Mr. Tatum? You raise your right hand, Mr. Tatum. I think I sworn you in earlier, but just to make sure, do you swear or affirm that the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Make sure you speak into that microphone so we can all hear you.
Yes, sir.
State your name, Mr. Tatum.
Tony Tatum.
You're aware you were on probation, correct?
Yes, ma'am.
You could speak up, sir. I can't really hear you.
Do you remember Officer Gallogly counseling you about the timing, about the requirements of probation?
Yes, ma'am.
Did you understand them?
Yes, ma'am.
Why didn't you call probation officer Gallogly to let her know you were at the restaurant?
I wasn't at the restaurant, that's it.
In the video that we just saw, you told the law, was that you in that video, by the way?
Yeah.
And those are words that you said? Someone forced you to say what you said?
What I say? I just said ain't nothing happened.
You also said she didn't want to pay for the food.
I ain't said nothing about she ain't want to. I say she asked me to pay for the food. She called me and asked me to pay for the food.
But then you had an altercation. You said that you had an argument. Right?
Yeah, we had an argument on the phone.
And you were at Juicy Crabs.
I wasn't at Juicy Crab.
Everybody else is lying.
Yeah,
Do you know LaPortia Baker?
Yes, ma'am.
Are you related to her?
That's my child mother.
No other questions, Your Honor?
Questions for him, Ms. Rivers?
No, Your Honor.
Take your seat, Mr. Tatum. Any other witnesses?
No, Your Honor, no, just argument.
Rivers? All right, Ms. Leone, I'll let you argue first.
Yes, thank you, Your Honor. Your Honor, in a violation of probation hearing, the state has the burden to prove that the defendant violated by a preponderance of the evidence, and nothing more than that. In other words, the standard is the greater weight of the evidence enough to sway the conscience of the court. As the court has pointed out earlier, hearsay is admissible. And I would ask, before I continue, Your Honor, for the court to take judicial notice of the court's file in 20 CF 1826, 20 CF 2406, and the newest case, 24 CF 2304. And all the contents, of course, of the court's file.
I believe the court can take judicial notice that there is a court case number, but I don't believe the court can take notice of what is in the files. So I would object.
What exactly are you wanting me to
The
take?
plea agreement, Your Honor, the whatever affidavit have been filed with the court, statements that the defendant himself has filed for the court. I want the court to take judicial notice. Otherwise, I'm going to have to enter him into evidence.
I thought we were done with evidence.
That's why I'm asking the judicial notice, Your Honor.
Okay, so what exactly are you asking me to tell me? The whole file means I'm going to go have
The
to read
affidavit
the
of
whole file.
the court's file, the plea agreements that were filed, fingerprints of the defendant, statements made by the defendant, admission to facts made by the defendant, such as for a plea agreement, and that he was on probation, and that he also obviously violated probation 3 times, as is shown by the court's record. This would be the 3rd violation.
Anything regarding that, Ms. Rivers?
No, Your Honor, I believe she had mentioned a new case number, and that was what I specifically was objecting to.
So as far as taking judicial notice that there's documents showing that he's on probation, he pled to probation.
No objection, Your Honor.
As far as the new case is that there is a new case that belongs to Mr. Tatum. That's the notice that I want the judge to
Okay,
take.
there is a case.
Yeah, okay, thank you.
Yes.
As the violation report shows and the criminal record of the defendant shows, he is a violent felony offender of special concern. He was charged with a 2nd-degree burglary. And that was actually pled down to a 2nd-degree burglary because of a plea agreement. It was the time of COVID. I know this personally because I prosecuted him in the South End. And I'm very familiar with the facts of the underlying case. And the constant violence that the defendant has displayed throughout those years. He's been given many chances. He's got a prior, in the prior record, he's charged currently with a 2nd-degree burglary for the VOP cases, and he's got a prior conviction for robbery. Defendant, given the underlying charges and the grounds for violating his probation, has proven, obviously, that he's not a good candidate. He's been given, again, many, many chances, and he's just hasn't taken advantage of them. And also, what I want the court to notice is the amount of time that it took for him to be reinstated again, be given another chance, and then violating again with the new law. He was at a place where he wasn't supposed to be. There are witnesses. There is the 911 call of the victim that was entered into evidence. She identified the defendant. They are related. The defendant.
Did she say his name?
Yeah, Tony Tatum. Yes, Your Honor. She identified by his name. Mr. Tatum right now said that he knows LaPortia Baker because she's the mom of one of his children. The evidence that is present in the case and also for the underlying charges show that he has a blatant disregard for the law and for the regulations. Officer Galogli just testified that she tried to help him out. And let's remember, for how long? That was like 2 months before he violated again. She made several attempts not to violate him, to help him not to violate. That same day, she testified that he texted her saying that I'm home, coming back from work. So she didn't think that he was going to be somewhere else. And certainly she's testified that he didn't have permission to be somewhere else. When the defendant was arrested in 20 CF 1826, it was a burglary occupied by a lady and the child of this defendant. At the time of the incident, there were even independent witnesses. He was, I guess one thing that helped him a lot was the COVID. It was the time of COVID. So we reached an agreement, and he benefited from it.
Okay, Ms. Leone, he's accused of violating his probation and 2 new charges and the being away from the house. Why don't we talk about whether or not you've proved that first before?
That's
Sounds
fine.
like you're basically making a sentencing argument right now.
Yes, Your Honor. So, based on the testimony of Officer Corberson and the interview with the defendant, although he claims that he said or he didn't say, the interview, it's on the record. He mentioned juicy crabs, and he said that there was an argument, nothing happened, only something about paying for food. The point is that he was not at home where he was supposed to be at that time. And he was, again, observed by other witnesses, independent witnesses. Probation recommends that his term be revoked and he be sentenced to prison. It is the state's recommendation that he be sentenced at the very least to 53.77 months because that's what the guidelines require. There is no evidence that he should be afforded another chance and another downward departure. And I believe the court has to find him that he violated, and that has to impose at the very minimum the guidelines. It's a state's contention that being at a place where he's not supposed to be is a willful and material violation that would require revocation of probation. He demonstrated that the defendant failed to follow very clear rules. And he said he understood the plea agreement. He was coached, he was instructed, yet he decided not to obey the requirements. He has violated those conditions. He's violated those conditions repeatedly throughout the course of this case. And the state, therefore, is asking that probation be revoked and he be sentenced to prison.
Your Honor, there was no evidence presented today that Mr. Tatum was in a place on that day where he was not supposed to be. In fact, we heard testimony from his probation officer or community control officer that he texted her saying that he had made it home at 5:19. All the testimony that we heard today was hearsay from people who had no knowledge of what happened. And we had a 911 call. The first person who was on the 911 call who was talking identified a person, did not identify Tony Tatum. The next person on the 911 call, they're not even here. No one's here. No one is here to testify. There has been no testimony, only no non-hearsay testimony. There has been only hearsay presented. No evidence has been presented that a crime has been committed. There's no evidence that has been presented that Mr. Tatum was not at his home. None. The only evidence that we have, and the only evidence that unfortunately, that his community control officer had was hearsay, a hearsay statement from the police. And we all know that the police reports are considered hearsay. The officer admitted on the stand that he had no personal knowledge. Only thing he had, he brought to court. You got to watch the interview as well. Mr. Tatum testified as well. This was a phone call. This was an argument over the phone, nothing more. So we believe that the state has not met their burden, and we're asking the court to find him not guilty of violating his community control.
Anything else, Ms. Leone?
Just want to say, Your Honor, that the statements that the defendant made are not hearsay. And the other thing is, conveniently, obviously, I would claim it would be a self-serving hearsay to say that, oh, I wasn't there when everybody was able to identify him, including the victim,
I
that
don't
he
think
knew
it's self-serving
personally.
hearsay. He said it in court.
No, what he said in the video,
Okay.
that's what I meant.
Well, what I'd like to do is, unfortunately, I got to take a quick recess to handle an injunction. I've been trying to handle what I can while we're up here, but I have to do that. But while I'm doing that, I'm going to listen to the recording again, because now that I've heard all the testimony, I want to go back and listen to it. So I'm going to go as quickly as I can, but I think I need to listen to it again, and I'll do that while I handle this injunction that's 24 pages long.
That's fine.
All right, we'll take a quick recess.
All rise, please.
So, and obviously, as we've talked about, VOPs can be done with hearsay. Hearsay is admissible. It can't be the sole basis. I did a little bit of research regarding this particular issue because, frankly, I'm not sure I've ever had this come up before. But I'm looking at, I'm not sure if it's RUISE, but RUISE versus State 43 Southern 3rd 885 states that hearsay is admissible in a probation or community control violation proceeding, but probation or community control may not be revoked solely on the basis of hearsay evidence. Revocation may, however, be based solely upon hearsay evidence that falls within an exception to the hearsay rule, which, because it kept saying non-hearsay. Every case you look at says non-hearsay. But some people would say that if it falls under an exception to the hearsay rule under 90.803, then it's non-hearsay. I don't agree with that. I think it's still hearsay. It's just an exception to the inadmissibility rule of hearsay. So, but according to this particular case, which is a first DCA case, it says that something that falls with an exception to the hearsay rule is sufficient. Since I believe that she was still excited from the event, that was a physical altercation between her and Mr. Tatum, I believe that falls under, 90.803. 2, excited utterance, a statement or excited utterance relating to a startling event or condition made while the declarant was under the stress of the excitement caused by the event or condition. So I think that's sufficient to corroborate all the other hearsay evidence that was brought in. So I think as far as the battery, the state's proven that that by a greater weight of the evidence or preponderance of the evidence that Mr. Tatum has violated his probation due to that allegation. I don't think there was anything that I heard in the evidence about the phone from the alleged victim in the case. So I'm going to find that the state hasn't proven allegation number 2, but also because he was at the restaurant 2 to 3 hours after he had already checked in that he was back home. That's a violation of his community control for not being where he was supposed to be at that point. So I'm going to find that the state has, by a greater weight of the evidence, proven allegation 3 that he was away from his home when he shouldn't have been. All right. Based on the fact that I'm finding that he's violated his probation, do we want to go forward with sentencing, or do we want to go have that come back? Ms. Leone, Ms. Rivers?
I would be fine to go forward with sentencing. I don't have anything to add.
Okay. Is there a score sheet?
Yes. Oh, yes.
Ms. Rivers, do you want to make any argument regarding any downward departure?
Your Honor, based on discussions with my client, he is asking the court for a downward departure sentence based on the new score sheet. He said that he would be in agreement with and believed that 33 months was appropriate.
I'm not sure what I could possibly find as a reason. To be honest, I looked at 921.0026 regarding certainly the enumerated reasons, mitigating circumstances that would allow for a downward departure.
And Your Honor, if you note, it does say that those aren't the sole reasons. There can be additional reasons. And in this particular case, based on the evidence that was presented, it was all hearsay. The court was able to, note that there is a case that says that you can find the person guilty due to the exception there. But based on the lack of evidence that the state has in this case, and you don't even have the supposed person here, there's no one here, I would argue that in itself should be mitigation for his sentence.
Okay. Ms. Leone, anything about that?
Yes, that case is not part of the score sheet and the sentencing, so whatever is done, we're here for the violation of probation, and I'm handing may I approach?
Yes.
Second, it's true that those are not the only grounds for mitigation and a downward departure. However, the defense has to bring up some evidence, substantial evidence, to support a downward departure, and they haven't.
All right. I'm going to find, I haven't found, seen or heard enough evidence to justify a non-enumerated reason mitigating circumstance under 921.0026. I did find that there was a violation of the probation because I haven't seen a reason for downward departure. I don't think I can do so at this point. And the other, I guess, put this on the record, I've got real concerns about Mr. Tatum's willingness to tell the truth here today. I think it's pretty clear by the evidence that he was there. His testimony today that he wasn't even at that place, I find to be less than credible. So based on that, I'm not willing to do a downward departure either. So Mr. Tatum, based on the court's finding that you violated your probation, and the score sheet calls for 53.775 months. I'm going to sentence you to 53.775 months in the Department of Corrections. I believe it will be a $100 VOP fee as well as a $150 public defender application and representation fee. I'm going to put those to judgment.
And Your Honor, credit for all time he's previously
Credit for all
served.
time served, definitely.
So this credit,
Mm-hmm.
like all my credit.
Mm-hmm.
All right. Mr. Tatum, you have 30 days to appeal the judgment and sentence of the court. If you can't afford a lawyer, one can be appointed for you. Just make sure you do something within 30 days.
Okay, I would like to put in for appeal too, though.
Okay, well, Ms. Rivers, certainly you can handle that for him.
We'll file notice of it in the second DCA does. Okay.
What else do we have to handle?
Judge, let me get Mr. Napoleon out of here. We've got a negotiated plea. In that case, it's going to be the time served. She's going to think about it and let me know.
Okay.
Mr. Napoleon, come on up, sir.
All right, this is 24 CF 809. Mr. Napoleon's here charged with possession of a controlled substance and possession of narcotic equipment. Mr. Napoleon, can you raise your right hand to be sworn? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name and date of birth, please?
William Joseph Napoleon Jr., 10582.
Okay, you put your hand down, Mr. Napoleon. You've heard what I just said. You were charged with possession of controlled substance and paraphernalia.
Yes.
Possession of controlled substance is a maximum 5-year incarceration and 1 year for the paraphernalia. I've been handed a plea and sentencing agreement that calls for an adjudication on both of those charges for, with a sentence of time served, $615 in court costs, and $150 PD fees. Is that what you want to do here today?
Yes, sir.
All right. You know this would make you a convicted felon.
Yes.
Is that a concern of yours at this point?
I mean, it is, but not, because I'm already convicted felon.
You already are. Okay.
Yeah, so.
That's just what I wanted to ask. All right. Did you go over this form with Mr. Williams, your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Did he answer all the questions you may have had about this?
Yes, he did.
Are you satisfied with his work on
I
your
am.
case? You are?
Yep.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Any mental health issues or concerns?
Nope.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
Do you understand there won't be a trial of any kind where the state would have to prove beyond all reasonable doubt that you've committed these offenses? You understand that?
Yes.
Okay. You nodded, but you didn't.
Yeah.
All right. And so what is your plea?
No contest.
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty. Time served, $615 court costs, $150 PD fees. How much time do you need to pay that, sir?
3 months, 3-4 months.
I'll give you 90 days, but you can make a payment plan with the clerk's office. Just make sure that you get in there before that 90 days is up. It's my understanding that this is a downward departure based on a plea bargain. Is that right, State?
Yes, sir.
Okay. And this is the state's agreement?
Yes.
All right. I need you to be fingerprinted, Mr. Napoleon. You have 30 days to appeal the judgment and sentence of this court. All right. What else do we have?
Judge, I also have Cody Lee Hinesley. Mr. Hinesley's present. Come on up, Mr. Hinesley.
This is a case where he wasn't present initially.
Yes, sir. He was not present this morning. It turns out, I checked with my secretary, A notice did not go out to him. We were able to get a hold of him and get him here, though. He is, we had Dr. Zeman do an evaluation on him. Dr. Zeman came to the conclusion that he's now competent. He was referred to a conditional release program, and ma'am, I've already vapor locked on your name, I'm sorry. Ms. Volontier? Yes. All right. Ms. Volontier is present. She's fully credentialed at this point, but needs a little bit more time with him to see if she agrees with that assessment. So if we can send him out, how much longer you figure you need, ma'am?
How about June 3rd? Is that too much time? Sooner? Well.
If not, that's fine.
Is March 27th too soon?
Do we have any April?
Only if I put it on the pretrial conference. Do you want to put it on that, on April 28th?
Since hopefully, well, we still have to have, it's a short hearing, but we still got to provide you with the reports, and then you make a decision. But can you get us a written report by then? All right, let's do that then.
April 28th, 1:30. April 28th at 1:30. Make sure you're back on that date, Mr. Hinesley. We didn't issue a KPS this morning, right? I didn't.
No, we did
Just
not.
want to make sure that we withdraw it if there was one.
All right, let me, give me just one moment, Cody, and I'll write that down.
I'll find you right now.
You are? Okay, great, thank you. She's going to give you something in writing, okay? All right.
Thank you, Mr. Hinesley.
Thank you.
Excuse me? Horn should be quicker. Yes, sir.
What are we doing with Horn?
What are we doing?
Horn, well, like I explained, when I spoke with him, he was wanting to continue the hearing, and we talked about maybe bringing it in.
So you haven't confirmed with him yet?
Well,
what
when
he
I
wants to
talked
do?
with him before, you still want me to continue the hearing and look over those new documents?
Yes, sir.
Okay.
Make sure everything's right.
Okay. And what I'll do is,
Thank you.
when is our next date that we can do him, Judge?
I mean, the next miscellaneous is at March. I mean, we can try to stick one after an arraignment day.
I was suggesting, Your Honor, also next week, I check with Trooper Avery if maybe,
He might disagree after he's been sitting here all afternoon and come back again. So.
I asked him, so it's up to the court.
Well, I'm fine to do stuff next week. I just found out that the 3-day trial I've got the week after next may have just exploded on me as well. So whatever days y'all want to do, I don't want to force you into anything if you feel you need more time than next week.
Judge, the other thing he's asked me to do is bring a bond motion for him, but I can get something drafted up on that.
Why don't we
and
put
then
it
we can
on-
either hear that or the other next
What did we
week.
say, the 13th at 1 o'clock for the other case that we,
That's what we
for
did
next
the other
week?
case. I'm fine at 2
Does that
p.m.
work for you, Trooper? Thursday at 1. Okay. And obviously, if there's going to be a reason why we can't go forward with it that day, make sure everybody knows about that in advance, and we don't have everyone sitting around waiting for it for hours. I apologize. Fortunately, I guess we're not continuing this because of a time issue. It's just there's new documents, but
Yes, sir.
I didn't know that was going to happen, so I would have tried to get the trooper out of here earlier and maybe Mr. Horn back earlier.
What is the time that day, Judge?
1 o'clock.
1 o'clock, 1 p.m.?
Basically right after our pretrial detentions, if we
I
have
see,
any.
Judge. Okay. All right. All right, I'll see you then.
What day is it?
Next Thursday.
Week from today, sir.
Is there any way you can come up and talk to me?
Yeah,
'Cause
yeah, I'll come
I
out and
need
see
to
you
talk to you
between
about
then.
the failure of appearance that I got accused of the last time that it never existed.
Okay.
And then we have
And she made me look bad that day, so I
Okay.
couldn't get a bond, you know?
Yeah.
Called me a flight risk, remember?
Right, I remember. Okay.
Okay.
All right.
All right, so we're here on Mr. Gormley's cases 24 CF 1248 as well as 24 CF 918. I guess the big issue is about credit for time served, is that right? What date are you saying he should have credit back until?
Judge, if I read the documents right, it's going to be 12/7 of 23.
Here's my issue with that. These charges weren't even filed then. These charges weren't filed until April, and he wasn't brought in until May.
Yes, sir.
So how can I give him credit back to December the year before?
The hold was placed on me then.
He's indicating that he believes that the charges were filed the year before. What the judge, I think, is going based off of is the date on the charging document, the information. Now, you had charges in several different counties, essentially the same charge. Let's look at the...
Yeah, when I was arrested in Escambia County, they placed a hold on me for Okaloosa County for these charges. The day I was arrested.
These charges were issued based on a direct file information on April 19th of 2024. They maybe hadn't been investigated, but you weren't charged and you hadn't been arrested for
There
them.
was a hold placed on me in Escambia County, Your Honor.
How is there a hold if there's no case?
There was absolutely a hold when I was arrested on 12/7/2023 in Escambia County. There was a hold placed on me for Santa Rosa County, and there was a hold placed on me for Okaloosa County. 100%, Your Honor. I mean, essentially, if I'm sentenced to 54 months now, which I have no problem with signing the global plea deal, I'm getting an additional 6-month sentence. All the gain time I've accrued that I busted my rear end for, I got my GED or my diploma as soon as I got to prison. In 40 days of arriving, I got my diploma. I've been committed to doing nothing but getting past this and getting my
understand that,
life
Mr.
straight.
Gormley. What I'm saying is, my case says it was started on April 19th, 2024.
I didn't bring.
Hold on. That's in 918. In the 1249 case, that one's listed as an arrest report. I think the issue, wasn't there, let me look at it again. That one was dismissed because they basically had two different cases.
Yes, sir.
Let me look at the arrest date on that. Again, if you can show me something that shows you had a hold, I don't have that.
I would have brought that if I mean no disrespect to my attorney, but we've been in constant contact with his office, and nobody has taken the time to.
What do you have that shows that you had a hold?
I had the arrest the affidavit from when I was arrested in Okaloosa County. I had the paperwork that I was provided when I was taken from Escambia to Okaloosa County and arrested.
When was that?
That was in May of 24 that they moved me for that day. But the hold was placed on me on December 20.
What was the basis for the hold?
That warrants coming out of Okaloosa County, the original warrant from Beverly Steele. The original warrant from Beverly Steele was filed in the summer of 2023. 2023. Absolutely.
So hold on. I'm not saying you're wrong. I'm just trying to find it.
I apologize. I'm just
All right,
tired.
so
I've been
I've
here
just
12
looked through.
hours
So
today.
in the case that's actually been dismissed, the 24 CF 1249, because basically there was an arrest and then there was a direct file, and there's two separate cases. The case where there was an actual arrest is the one that's dismissed. However, as I've just gone through that one, the arrest report from 5/29/24, page 12 of 13, shows a warrant signed by Judge Clark on December 20th of 2023 with a return date of the 28th of December 2023. So I don't think it necessarily goes back to December 7th.
17th, I think, Judge.
It was 7th.
Yeah.
It was the 7th.
Was it the 7th? I thought it was the 17th. Okay.
Because when I went to Escambia County, they immediately told me, they said, you have holds in.
Well, you're telling me that, but I'm telling you the warrant wasn't signed until December 20th.
I would have brought all this stuff with me, but I didn't think I had to provide my attorney with all the,
Well, again,
documents.
I've looked at everything. And again, there was a direct file capias. I'm just not sure why that was done, other than there's just a cross in paperwork at some point. But the warrant wasn't signed until December 20th.
So do I get credit from December 20th of 23?
That's what I would think. I mean, we're talking about 13 days of credit difference.
That will do, Your Honor.
Okay, again, this is why I'm looking through everything,
I
but you gotta
appreciate-
help me. I went back and watched your plea hearing in front of Judge Duncan. I did that in the 20-minute lunch break that we took. And I got all the numbers off of there, showing what credit you did have in both Santa Rosa and Escambia County, and saw everyone was giving you credit to December 7th. But I don't think I can go that far because the warrant wasn't signed until 13 days later. But I will give you credit from December 20th of 2023.
Could that have been the day, December 7th? Could that have been the day that I was charged with that the warrant was issued for Darren Mason?
I don't know which cases.
That's the other case that I'm before you on right now, sir. I'm here for two cases. Because I took this global plea.
Judge, there's 918 and 1248.
For some reason, 1248 is not coming up when I pulled up his name.
In one of them, there's a middle name associated with it.
I'm looking at it now. Let me look at this one.
They had
That was the part of the problem. I was looking at two different. One that's not on the docket and one that is.
But when I was first arrested in Okaloosa County, they had me down as having first-degree felonies. So I had to wait before I went before the first appearance judge for her to fix that in the system.
Okay, I haven't looked at 1248 because when I clicked on your name, it didn't give me that case. It gave me 1247. So now I'm trying to look at that. When was that one signed? That one was signed June of 22. No, I'm sorry, September of 23. All right, I'm going to give you credit to December 7, 2023.
Thank you very much, Your Honor.
Sorry.
No, thank you.
I've been trying to dig my way through this, rabbit trails of cases. I'll keep my comments to myself about when you have so many cases. These are the kind of things that happen. But, all right, so credit would go back to December 7th. You've been continuously incarcerated since that date. And this warrant, sorry, I laugh, but I just looked at it. I'm the one that signed the warrant in September of 2023.
All right, Mr. Gormley, if this is what you want to, or Gormley, if this is what you want to do.
Can I read this?
Yes, the same thing that you have. Or if you want more time with it, we can bring you back next week.
I do not want to come back if I can avoid it, as I'm sure the judge does not want me to.
He finally got me to say what he wanted me to say. He doesn't want to take any chances. I'll look at the file again. All right.
You want to take it back and then come back
Sure,
out?
why
in a
don't I do
minute?
that so to keep things moving?
There you go.
Thank
All
you.
right, keep reading it,
No
and then we'll
problem.
bring you right back.
All right. Judge, this is on for a contested hearing. She has a 30-month suspended sentence. The state provided a corrected score sheet a few minutes ago. I've gone over that with her. She now scores the lowest permissible of 45.5 months.
46.5.
46.5 months. And the state was willing to let her plead to 30 months. I went back on the break and spoke with her and asked her if she still wanted to proceed with the hearing, and she does.
We ready to do that today?
Yes, sir.
Yes, sir.
Come have a seat over here, okay? Right over there. They always want me between clients and the prosecution.
So just to make sure we're clear, this is a VOP evidentiary on Christy Leanne Holly in 21 CF 3096, 23 CF 1405, 24 CF 961. What is the affidavit that is the basis for the violation that we're using here?
A positive urinalysis.
Where is it? What date was it filed?
I'm not
I'm trying to find it, but there's just a lot in here.
It was part of the, I believe, the violation report. It was attached to the last couple of pages of the violation report.
Here it is, August 7th, 2020. I would just want to make sure I'm finding the right one and there wasn't an amended one that I missed or something like that.
Yeah, the date of the report was August. I think the urine was collected July 23rd.
All right, so the sole allegation is that there was a positive urinalysis. Urine sample was obtained from Ms. Holly on 7/23/24 and confirmed by the lab for fentanyl, is what it says on August 5th. So that's the sole allegation?
Yes, sir. Yes,
All
Your
right,
Honor.
you agree with that, Mr. Williams?
That's correct, Judge.
Okay. All right, you ready to put on evidence?
Yes, state would call Officer Aaron Galugli.
I swore you in earlier, but that was a different case. Do you swear or affirm the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Good afternoon.
Good afternoon.
Please state your name.
Aaron Glogly,
And what is your occupation?
Correctional Probation Senior Officer,
And how long have you been so employed?
approximately 8 years.
And as part of your employment, do you supervise on probation and community?
Yes.
Do you supervise Christy Holly?
Yes,
Do you see Christy Holly in the courtroom today?
I do.
Please point to her and identify her by an article of clothing.
She is sitting there in an orange jumpsuit.
Please let the record reflect the witnesses identify the defendant.
It will so reflect.
And when did you begin supervising Christy Holly?
June 6th of 2024.
And prior to that, was she supervised by another officer in your agency?
Yes,
As part of your occupation, do you have care, custody, and control of the file pertaining to her supervision?
yes.
And when did you assume custody of that file?
June 6th, 2024, yes.
Are there records and documents in the file that are filled out or completed at the time of or shortly thereafter obtaining the
Yes,
information? And do you or a member of your department fill that out?
yes,
And that's done pursuant to a legal duty to do so?
yes.
Does your file indicate that Christy Holly was placed on probation or community control?
Technically both, probation and community control. She had 3 separate cases.
Was it first probation and then later community
Yes,
control? So currently, we're talking about a violation of community control.
yes.
Can you tell me when she was first placed on any kind of supervision?
Yes. Just a second. In 21 CF 3096, she was sentenced on 12/27/22.
And are you aware of approximately how many times has she violated her supervision since that date?
This would be at least the 3rd.
Does your file indicate that Ms. Holly was advised of the responsibilities and duties of being on community control?
Yes.
And when was she advised of those duties?
Once again, she has 3 separate cases.
I guess most recently.
Okay, yes, the most recent one would have been May 6th of 2024.
And do you have her execute a document acknowledging that she has been reviewed through all the conditions she has to comply with?
Yes.
And you reviewed that document with her in May of 2024?
Yes.
May I approach the witness, Judge?
Yes, this is her order of community control. This one signed August 15th, 2024. The reason for the different times is we have them sign a temporary order, and then we have to get an official one from the judge. Once that one comes back, we have them sign it again. But she signed a temporary order on 6/6/24, where she was instructed originally.
And for the record, I was showing Officer Gulligly what I have to previously mark it as State's Exhibit 1.
Okay.
Does the document include the condition that Ms. Hawley refrained from using illegal narcotics?
Yes.
Is that condition number 7?
Yes.
And she understood that condition?
Yes.
Did you file an affidavit for violation of probation?
I did.
And the basis for that is just this, what we've talked about, the urinal. We already talked about the urinalysis.
Yes.
Recognize this document?
I do. It's the affidavit I filed for the violation of probation.
Is it in, has there been any changes to this document?
No.
And would you please explain the violation, how you were made aware that the defendant had violated her community control?
She was in the office and she was asked to submit a urinalysis. There had been suspicion that she had been using. She had previously admitted to using. We tried to work with her. We went ahead and did a urinalysis, which was presumptive positive in the office for fentanyl.
I'm
And
just
then
going
we.
to slow you down for a second.
I'm sorry.
No, that's fine. You're answering my question, but I'd like to ask you that you said there was a test in the office?
Yes.
And that was administered by you?
Yes.
That was, what date was that?
If I can look at the report. That was July 23rd of 2024.
Okay, and that was, we might call that a field test?
Yes,
Is that
that
commonly
is
referred
correct.
to as field? Is that what you would call it? Or just
We would just call it a urinalysis in the office, but yes.
office urinalysis?
Yes.
And did you test that for results?
Yes.
How did that, what were the results?
So we tested in the office. It was presumptive positive for fentanyl.
Judge, I'll object to the test results because it's merely presumptive test. If they were sent off to a lab, they can rely on the lab results if they get that in. But the presumptive test has not met the Fry test.
Judge, I have a legal support for the proposition that what I would call the field test, what we're talking about, a office urine test, is competent non-hearsay testimony because it was administered by Officer.
The question is not whether or not it's hearsay, Judge. The question is whether or not it meets the Fry test. Is it generally accepted in the scientific community as being a valid test?
Let me just stop you for a second. Florida doesn't use the Fry test, it's Daubert.
Or Daubert, I'm sorry, Judge. I
In,
meant Daubert.
Judge, the Supreme Court of Florida, State versus Quior, Q-U-E-I-O-R, 191 Southern 3rd, 388, 2016 case. In that case, there was, I believe the sole basis was a urinalysis. Sole basis for violation of probation was urinalysis. The lab report was admissible hearsay at the VOP hearing.
I don't think he's objecting to the lab report. He's objecting that the presumptive test is not sufficient.
Right, and the Supreme Court of Florida found that field drug testing is, quote, routine and ubiquitous such that judges throughout the state are well-versed in the procedure, citing a 50 CA case. In fact, studies show that field drug testing is highly reliable, even when the test is not administered by a trained lab analyst. And it cites a 50 CA case, citing overall error rates, which were very low. So, Judge, our position is that if it's good enough for the Supreme Court of Florida, it should be good enough for this court.
All right.
Only if that's the issue being presented in the case, Judge, and not dicta.
All right. Rather, given the established reliability of field drug tests and their commonplace use in VOP proceedings, which are subject to relaxed evidentiary standards and a lesser burden of proof than a criminal trial, requiring the state to trot out an expert, like in a case like Quarriers, where the field test has been confirmed by a lab test, is unnecessary to satisfy the conscience of the court that a probation violation has in fact occurred. So I still think it's saying as long as there's the other test.
And I'm getting to that, Judge.
Okay.
You want your
I'm going to overrule your objection to the point that, but give it the proper weight that this is just the field test. This is not the lab report, which I think is coming because it's talked about in the affidavit. But
yes,
go ahead.
Thank you. So I believe you said that the office urine test tested presumptive positive for fentanyl?
Yes.
And what did you do with that sample?
So after that, we follow all of our chain of custody. We send it off to the lab, and then we wait for the final results that come back from the lab.
Yes.
Recognize this document?
I do.
And how do you recognize it?
This is the drug test report we get back from the lab, and this is the chain of custody form that we send with the sample.
And this is, in fact, this is the lab test report for Christy Hawley?
Yes.
Of my exhibits in, I was kind of going to do that all.
You have not. You have not.
Yes, I know. I would move it. I've previously marked this State's Exhibit 3. I'd like to move this into evidence.
3?
Yes.
Objections?
Well, Judge, it is a violation of probation, so hearsay is admissible. Can't be based solely on hearsay. The report is hearsay, so subject to that, I don't have an objection. I realize that
you said there's a record certification with it?
There's a chain of custody.
Yes, Your Honor, there's a chain of custody that we fill out, we sign, we send it off, they fill it out when they get it, they fill it out when they complete it, and then they send it back with the report to us.
I'm not arguing chain of custody. I'm talking about the business records exception. You can do that by affidavit, and I think that's what we're asking about.
I can't see what you're looking at.
No, sir. We haven't filed a notice to admit as a business records certified record.
Then I would have to object, Judge.
Can I see what it is? So your objection, Mr. Williams, is not that it's not admissible, because this is a VOP hearing, but that you just want to make sure that we're all referring to this as hearsay, so you can make your hearsay
Yes,
only
Judge.
argument later. All right.
That's correct.
I'm going to admit it. I don't see what exception to the hearsay rule this would fit, because it doesn't have a business record certification, so I'm going to classify it as hearsay, but admissible because it's a VOP.
Thank you, Judge.
And Officer Golugly, just, I'm not sure if I asked you earlier, but the lab report did confirm also the presence of fentanyl in the Holly's urine.
Yes.
Did you speak with Christy Holly about the results of the drug test?
I spoke with her before I took the test and after them, yes.
And what did she say to you?
Before I took the test, I asked her if she was going to pass, and she said no. After the test came back, I explained to her that I have tried to work with her. I wasn't sure if the court was going to ask for a warrant, what they were going to do, but that she would this did violate her probation by being positive for fentanyl.
So she never admitted the positive urinalysis to you?
I'm sorry,
she never admitted well, she said that she wouldn't pass, but she never told you anything
She
else.
did admit to using. She did admit to using illicit substance.
Was that?
It was before.
In reference to this urine test?
Yes.
As well? Okay. So you said that, I think you worked with her?
I did. So if
Could
I
you tell me a
may.
little bit more about that?
Yes. So when she first got out of jail, she went between a few places. She didn't have a stable place to stay. I reached out to the Oxford House for her. We actually got her a bed. I don't know if you're aware of the Oxford House, but it's a sober living house where everyone that lives there, kind of works together, pays the bills together, but it is managed by another entity, i.e. Oxford House. They even agreed to waive her move-in fee because she had just gotten out of jail. She went through the interview process. She got accepted to the house. I think she stayed there less than a week for sure. Might have been about 4 days, and she left.
And I just want to clarify the timeline here because it's my understanding you had already taken over the file and were personally supervising Miss Holly when you helped her get into the Oxford House.
Yes.
And that was not court-ordered, but you helped her get in, and she decided to walk away from that after just a few days.
Yes.
And so prior to that, at that time, did she still have, I guess I want to kind of go back.
Okay.
To the time when she was given the Keaton, she was ordered to attend the Keaton program, and also given that suspended sentence.
Yes.
Can you tell me when that was?
Yes. So on October 26th of 2023, she was reinstated on the 21 CF 3096, modified to enter and complete Keaton with a 30-month suspended sentence. On April 2nd of 2024, she was unsuccessfully discharged from Keaton, which violated her probation. And then...
In those two cases at the time?
Yes, there was two cases at the time. And then while she was out of Keaton, after being discharged, she got a new charge on April 4th of 2024, which is the 24 CF 961 case. She was modified to then to community control, and they once again gave the 30-month suspended DOC sentence.
They kept it suspended?
Correct, they did not impose it after she got kicked out of Keaton.
And that was the time that she was put on community control?
Yes.
And that was the time that, although she was not ordered to go to Oxford Sober Living, you did help her get in that?
Yes, she was sentenced on June 6th of 2024, and then shortly after she got out, that's when I helped her get into Oxford House.
Do you believe that Ms. Holly should still be under supervision?
No.
Do you believe that the only resolution in this case would be to impose incarceration for Ms. Holly?
Yes.
Is there anything else that you would want to tell the judge about your supervision of her?
Objection calls for a narrative. I
I'll
realize I'm letting a lot
I'll
of
withdraw the question.
sentencing stuff come, but
Judge, I would like to admit what's been previously marked States Exhibit 1 and 2, which is the order of community control that she signed, and the affidavit of violation of probation.
Any objections, Mr. Williams?
No, Judge.
1 and 2 will be admitted without objections. Pin them to the
And I also have one more. May I approach the witness, Judge?
Sure.
You recognize this document,
I do. It's a violation of probation report that I did with my recommendation on the back.
and that's how you recognize it?
Yes,
Do you see any changes that have been made to it since the time that you authored it?
I do not.
Judge, again, I think the recommendation and all that comes in more as a sentencing issue, but in the interest of time, I don't have any objection.
Or will be admitted. All right, Mr. Williams, cross.
Thank you, Judge. All right, and again, I'm trying to move things along, and so rather than split it into first guilt, innocence, and then sentencing, we're kind of addressing all of it at one time. But when you brought out about the Keaton program, was she kicked out of Keaton because she was in possession of a non-prescription pain reliever, specifically Tylenol or acetaminophen?
She was kicked out of Keaton for not following the rules.
Okay. And was the rule that she didn't obey having a non-prescription, over-the-counter, acetaminophen-based pain reliever?
I don't recall. I didn't supervise her at that time.
Okay. All right. You also were asked a question about admission, and you gave sort of a conclusory answer, all right? Specifically, as best you can recall, what did you say to her and what did she say to you? The only thing that we had directly was you said you asked if she was going to pass and she said no. What else did you say to her and did she say back to you that causes you to say she admitted using? As best you can recall, if you can recall, what was the actual conversation?
As best I recall, I asked her when the last time she used, and she said within the last couple of days.
She said within the last couple of days, or you asked her, was it within the last couple of days, and she said yes?
My question was, when is the last time you used?
Okay. And her answer was within the last couple of days.
Yes. In my experience, if you would like for me to elaborate, people that use drugs a lot kind of confuse their days and times. So days kind of run together sometimes.
But they usually try to give you an answer, don't they? They don't usually
It's not
say,
always
well,
truthful.
within the last couple of days.
It's not always truthful.
Well, I'm not asking you whether or not you believe she was truthful. Clearly, you believe she was not. All right. Have you had any contact with Keaton since her arrest for this violation of probation with regard to whether or not they would accept her back?
No.
Would it surprise you to know that they would? I don't have any further questions, Judge.
Redirect, Ms. Turner.
Yes. Part of your routine duties is to administer drug tests, is that correct?
Yes.
And you've been trained in how to do so?
Yes.
And you're trained to interpret the results?
Yes.
Approximately how many times have you administered a office urine test?
Well over 100.
And how do you collect the sample?
It's observed. We go in with the individual.
So So you did that.
I'm going to object. I believe that's outside the scope of my cross. I didn't ask her anything about how she does the tests. I made my objection, but I didn't answer any questions about the nature of the test or how she does it or how trained she is in doing so.
Yes, Judge. I mean, I did ask previously about collecting the urine.
I understand, but he didn't ask anything about those things on cross, which means it's beyond the scope.
Yes, Judge, I was just about to get into the collection, so I can cease my questioning.
Anything else for this witness?
Thank you, Your Honor.
Any other witnesses?
No, Judge. No, Your Honor.
Williams, anything?
Judge, I would call my client to the stand.
Come on up, Ms. Holly.
Actually, Judge, can I have 5 seconds with her first? Make sure she wants me to. Judge, I'm going to go ahead and call her.
Come on up. Raise your right hand. Do you swear or affirm the testimony about to give the truth, the whole truth, and nothing but the truth? Make sure you speak into that microphone for us.
Okay.
Go ahead, Ms. Williams.
Thank you, Judge. Please state your name for the record.
Christy Leanne Holly.
All right, Ms. Holly, I want to ask you about the drug sample that you gave, okay? Had you knowingly used any illicit narcotics?
No, sir, not at all.
Had you had a situation with a fella where
Objection, this is improper direct.
I'll rephrase
It's
it.
leading, so.
Tell the judge about how you believe drugs might have been introduced into your system.
All right, a couple days before I reported to probation, I had gone to pick up my belongings from where I used to stay. It was about 2 o'clock in the afternoon when I got there. The next thing I clearly remember was it being dark, and I was outside on the ground, and I saw two men walking away from me. I recognized one of them, but I didn't recognize the other one. I was extremely confused about where I was, even what day it was. I had called someone to come pick me up, but I told them the wrong place, even though I was standing in the yard and it was somewhere I had been plenty of times. For some reason, I didn't know that's where I was. The next day, my mouth was swollen, and when I woke up and went to get in the shower, when I took my pants off, I had dirt and ashes fall out of my pants, and my backside had burns on it. I wasn't exactly sure what had happened. I was really confused, and I just kind of kept pushing it out of my head because I didn't want to believe that anything like that had happened to me. But I had no choice but to accept that something had happened to me whenever I went to probation, because I violated the urinalysis according to Ms. Gologly. And I wasn't anticipating that. My drug of choice was methamphetamines. It was never fentanyl. So I didn't exactly know what it felt like to do it the same way that I would have known if it would have been methamphetamines.
Now, Did you eat or drink anything while you were in anybody's company
I don't
prior to waking
exactly,
up?
I don't exactly remember. I just remember talking to the man whose place it was where my stuff was at and telling him that I needed to get my stuff. And I remember being in the living room. And then the next thing I clearly remember is, you know, it being dark and being outside. And I remember I was just really confused. And even still, when I think back on it, I still find it confusing. I mean, logically, I know what must have happened, but it just, at the time, didn't make any sense.
What do you believe happened?
I believe that I was somehow incapacitated and that my clothes were taken off because I had the ashes in my pants and because I had burns on my backside. And I believe that something happened with my mouth because of how badly it was cut up and swollen.
Did you intentionally take any fentanyl?
No, sir.
Did you intentionally take any other illicit drugs that were not prescribed by a physician?
No, sir.
Did you intentionally, on this occasion, violate your probation?
No, sir. And I continued to report every week, even after she told me that she had violated me, because I knew I hadn't done it on purpose, and I didn't know. I had kind of thought they were on my side, so I kept reporting. Like I had Miss Dana Claw go with me the next time to talk to Miss Galogly, because after I had failed the drug test, then I started to realize that I couldn't deny that something had happened to me. So I went to her and talked to her about it, because she's also been through something like that. And I was currently in her ECLC classes at the time. So she went with me to probation to talk to Miss Galogly. And then I continued to report 2 or 3 weeks afterwards, even though I knew I was going to be arrested and put in jail, because I knew I hadn't done anything wrong.
Do you have a clear memory of, and what I'm talking about is retrograde to when you woke up, okay, of eating or drinking anything? Or how big is the gap, the memory gap that you have?
From probably about 2 to 4 in the afternoon till between 12 and 2 o'clock in the morning is is how much time I'm missing.
All right, so do you believe that you have some retrograde amnesia from before?
I must, because the last thing I clearly remember before waking up was standing in the room talking.
Now
I don't know how I made it outside. I don't know what happened after that.
Have you made the decision or had you made the decision to report this incident or report any? Do you believe you were sexually molested, ma'am?
Yes, I do.
Have you reported that to law enforcement?
No, I went and talked to Miss Dana about it, and she told me that I could report it.
Objection.
Oh.
I don't think it's being used for the proof of the matter asserted, Judge. It's being used to show her state of mind.
She told me that I could report it.
Hang on a second.
The
Judge has to
question was whether she believes she was sexually molested. Ms. Claw would have no way to help her answer that question.
No, I do believe I was.
I haven't heard it yet, but I think the question, repeat the question.
I don't think that was the question, Judge.
She
I
was
think
answering something that wasn't.
Right, I think the question was, I had asked her if she thought that she was sexually molested, and then she talked about, and then I asked her if she had reported it, and I may have asked her why it wasn't reported. And I think that's where we got into the conversation about what Ms. Claw had told her.
I'm going to overrule it, but I'll give it the proper weight once I get a chance to hear what's said.
All right, so ma'am, why did you not report it, your suspicions to law enforcement?
Because I didn't know 100% that it had happened for a couple days, and I didn't want to report against this particular person without really good evidence, because I have fear of him. And I felt like, having not been sure about it for 2 or 3 days, that the evidence that was remaining wouldn't be strong enough to make it where I didn't have to be afraid of him, knowing that I had turned him in and him not being prosecuted.
Had you showered or bathed?
Yes, sir.
Had you brushed your teeth?
Yes, sir.
Have you ever been prosecuted before for possession of fentanyl?
I know I've been prosecuted for possession. I think along with the methamphetamine, there was opiates. I don't know exactly what kind of opiates, but I think that I think I have both.
Okay. Do you use fentanyl on a regular basis, or have you ever used fentanyl?
I've used pain pills, but mostly methamphetamines.
All right. Did you use fentanyl on this occasion?
No.
Let me just go ahead and ask so that it's clear. Is it your testimony today that you believe that you were dosed by this man?
Yes, sir.
And taken advantage of sexually?
Yes, sir, absolutely. I think he was maybe trying to kill me. I don't know if he expected me to wake up, because he had thrown me in next to the fire, and I just keep thinking afterwards, to have been out for so long, it had to have been a lot.
How long do you figure you were out?
From anywhere between 2 and 4 to 12 and 2, so however long that is, the whole evening and part of the night. And I don't think I woke up at all. I don't have any fragments or anything yet.
Again, Judge, just to kind of move us along a little bit. Well, I don't have any further questions, Judge.
Good afternoon. You said that 2 days before the urine sample, you saw, it was dark, but you saw 2 men around about the time that you had this amnesia, and that you were confused. You said that a lot. Is that correct?
Yeah.
You were very confused. I think you said it 3 or 4 times. Is that right?
Yes, ma'am.
You just didn't know what happened. You knew that your backside hurt, you were confused, and you had ashes in your pants and your burns on your backside.
Yes, ma'am, and my mouth was swollen.
But then later in the testimony to your attorney, you said that you were not 100% sure that you were sexually assaulted for a couple days. So what was it? Were you confused about what happened, or were you 100% sure that you were sexually assaulted? And what man did it? You said you saw two men, but then you started referring to one particular, you actually said this particular person. You said, I did not know 100.
Ms. Turner, maybe
Sorry.
ask one question, let her answer.
Yes. So which is it? Were you confused, or were you 100% sure?
No, I was 100% sure that I saw two men walk away from me in the dark. I still am confused about exactly what happened because I wasn't conscious. I only know the aftermath of it, which was that I had burns and ashes, and my mouth was swollen and cut.
Now, being confused is also a side effect of drug use, isn't that right?
I assume that it is.
You've used drugs in your history. You've testified to your attorney that you prefer meth.
Yeah, I don't.
That cause confusion?
Generally get confused from the meth. I'm mostly confused because I don't have any memory of what happened. I just know what was happening afterwards.
You said that you continued to report to probation, but that was because you knew how much trouble you were going to get in, wasn't it?
I knew I had violated and then I would get arrested.
And you knew you had the
But
suspended sentence.
If I'm being honest, in the past, anytime I violated, I ran. This was the first time that I ever didn't run. This is the first time that I ever faced up to whatever consequences, but it was because I knew that I hadn't purposely done anything wrong. But every other time I ever violated, I definitely ran.
And you knew what happened when you ran. So this time, you knew that if you ran, you would get in a lot of trouble.
That has never been something that, if normally I would run so that I could go and do drugs, but this time I didn't do drugs or run because I knew I had been diligently trying to do the right things.
In the first case before the court, the earliest case in 2021, you were on supervision for child neglect and possession of heroin. Isn't that right? Yes. And you were put on probation for 5 years, isn't that right? And you violated with positive urinalysis in that case, isn't that right?
I violated because I didn't report.
Is it a yes or it's a yes or no?
I don't remember exactly. All I know is that during that time, that's when my child's father and my fiance, he died in our camper. It burnt down, and I quit.
And you used meth?
I used everything I could probably get my hands on at that time.
Meth, codeine, amphetamine, morphine.
The love of my life had just died.
And that's a yes, for the record?
I did.
And you got arrested for introduction of contraband to the jail, 2 counts. So you were so addicted you had to bring drugs with you into the jail, isn't that right?
No, ma'am, I had an empty baggie stuck in the waistband of my pants.
So you weren't convicted of introduction of contraband, or you were?
I was.
That's before the court today.
I understand that, but when I got arrested at that time, I had a baggie in the waistband of my pants, and whenever I was being searched, it fell out.
And you were given you agreed to a suspended sentence, isn't that right?
I did, yes.
And then you were arrested again for drugs, correct? In the 24 case. 2 counts. Is that right?
I've been arrested for drugs. I don't know exactly.
Heroin again, meth. That's before the court as well.
Right.
You're on probation for that.
Yes, ma'am.
You have a suspended sentence. Those are all the things that you knew you had to lose if you violated.
Yes.
And you heard Officer Galogly testify that when she asked you, will your urine pass? You said no.
I did not say that.
If you didn't say it, then is Officer Galogly lying to the court, or are you,
Objection
ma'am?
improper. It's improper to ask a witness to determine whether other witnesses are lying or telling the truth. That's for the court to decide.
You never told her that?
No, ma'am. No, I did not, because I didn't know I was going to test positive. I didn't.
But you testified to your attorney that you knew you were going to violate.
No, I did not.
You said that you knew, you said you kept reporting even though I knew I was going to violate.
Once I had the positive urinalysis, I knew I was going to violate, and I still kept reporting. She told me that I was violated, and I still, for 3 or 4 weeks after I had been violated, still continued to report weekly, knowing that I was going to get arrested at one of those visits.
I don't have any further questions.
Anything else, Mr. Williams?
Yeah, let me look, Judge. Just one question. Did you willfully use any illicit controlled substance?
No, sir, I did not.
Thank you. Nothing further.
You can take your seat, ma'am. Any other witnesses or evidence, Mr. Williams?
No, Your Honor.
Any rebuttal by the state?
No, Your Honor.
Argument, Ms. Turner?
Yes, Judge. The burden of proof is, the standard of proof is preponderance of the evidence, the greater weight of evidence. You heard Officer Galogly testify that she took the urine sample from Miss Holly. She asked her, would she pass? And she said no. And that was the only day of the urine sample we're talking about was July 23rd of 2024. And that is that's not hearsay. That's a statement of the defendant. That's an admission. We also have the lab report from, I believe it's Alir, showing fentanyl in her urine. Corroborated by her own statement to Officer Galogly that she would not pass. Also corroborated by the, what I call the field test, what Officer Galogly calls the office urine sample that she took that also showed positive, confirmed for fentanyl. So the evidence before the court is well beyond that of the preponderance, or the greater weight has been shown that she tested positive for fentanyl, an illegal narcotic, that she signed the agreement number 7 saying she would refrain from using narcotics. Furthermore, you have her history of use. Each case involves narcotics in some way, shape, or form. And there's 3 cases before the court. This is the 3rd violation. I would urge you to consider her own testimony as self-serving. She knew, Judge, that she had that suspended sentence because she had it in October of 23, and they didn't lift it in June of 24. She knew what she had to lose, and that's the reason why she's telling the story that she's telling. Her story is not compelling. She could not remember anything. She said she was very, very confused. She couldn't remember anything. She couldn't even remember eating or drinking anything. And that would have happened before the alleged dosing, as it were, by these two mysterious men, although one she knew. And then later became 100% sure who it was. and 100% sure what happened to her. But, Your Honor, I think that that's self-serving. It's clear that she's just trying to deny the UA because she knows it's the only basis for this violation. So she kept reporting in order to be here today and try to cast doubt, but there's no doubt. It's a preponderance of the evidence standard, not beyond a reasonable doubt standard. And I think the evidence is sufficient for you to find that she is in violation.
Mr. Williams?
Thank you, Judge. Judge, as the court's aware, it can't be based solely on hearsay. If this were a trial, I would have moved for judgment of acquittal before placing my client on. Because what you've got is you've got a hearsay statement that forms the lab report that's the only recognized evidence. The field, she's calling it field test, the in-house reagent test is not admissible in and of itself. So with that, you've got really just hearsay. My client took the stand and testified and did not actually make any admissions. So we can't get past the sole hearsay problem with that. She described events that happened to her. She describes a degree of retrograde amnesia. So it's actually not surprising that she doesn't remember eating or drinking anything. She just knows that she wakes up, she's confused, and she has ashes, burn marks on her buttocks, some sort of issue with her mouth, and believes that she was sexually assaulted. She doesn't realize with any degree of certainty that she was drugged until the drug test comes back positive. Up until then, she's not really sure what happened, and she testified that she's afraid of this individual. And so she doesn't file any reports. She doesn't do anything like that. The burden is a low burden, but it's still on the state to prove. And they have to prove that it was willful. I'm not going to argue the substantial part of it. Somebody's on probation for drugs, uses drugs, that's going to be a substantial violation. The question here is, has the state proved by a preponderance of the evidence? Can the state satisfy the conscience of the court that it was willful in this particular case? Now, if the court finds that that is not proved, then she's back on supervision and we see what happens and whether or not there's any further violation. Thank you, Judge. No further argument.
Any rebuttal, Ms. Turner?
Yes, Judge. There was also no testimony from Ms. Hawley consistent with what would have made her believe she had been given fentanyl. The things she described, her backside hurt, she had ashes in her pants. Then to say she knew going into that drug test that it would be positive, she did not tell the court how she figured these men gave her drugs. In fact, she said, I don't use fentanyl, I don't know what that feels like. She was so confused, but she was trying to say that she wouldn't have known what that felt like. Otherwise, the only thing that makes sense, Judge, is that she forgot she took the drugs. She was with these men, she took drugs, she woke up confused because she took them voluntarily. And so if you find her to be credible about her lack of memory, maybe it should stop at that, because I think the rest of it is self-serving. It's not credible at all. There's no way for her to walk in on July 23rd and say, yes, my urine is going to be hot, based on what she said she described happening in the dark in her amnesia state. She said she had no experience with fentanyl, so how would she know? No further argument.
All right, the state's evidence involved a positive urinalysis that was not only the field office presumptive test, but it was sent off to a lab. The lab report was entered as evidence. I believe it's hearsay because it doesn't have a certification. So it is hearsay, but hearsay is admissible. It's been admitted and considered. I believe Miss Holly's admission, according to probation, that she knew she was going to be negative, or she knew she was going to be positive on the UA, and then ultimately that she would be positive, is non-hearsay corroborating evidence of that hearsay test. I don't believe the story at all, Miss Holly. I think it's, for that to have happened back before July 23rd, and it's the first seemingly anyone's heard of it, kind of speaks for itself. It's beyond self-serving. It's a statement made, in a hearing that has no basis in fact, other than it's the only story that can be made potentially to show you that you didn't do this willfully. And I find your testimony was not credible. So I'm going to find that you willfully and substantially violated your probation. Does either side want to be heard on sentencing today, or do we want to go off to another date? And there's a suspended sentence, correct?
There is a suspended sentence, Judge, of some 30 months. The only thing that I would really add to it is we did touch base with Keaton, and Keaton is willing to take her back. I've got an email chain from my investigator with Keaton to that. I think we already provided it.
I mean, this is the second time the suspended sentence has come up, right?
Yes, sir, it is.
I mean, to be honest, it's a suspended sentence of 30 months, but I think I heard she scored 40-some, correct?
46.5, Judge.
That's what I think I wrote down somewhere here, 46.5.
We just defer to the court, Judge. We're asking for the prison sentence.
The 30 months?
I believe
I think I'm capped at that. I don't think I can give any more than the suspended sentence.
If there were a new law violation associated with it, you could on the new law violation.
Of course, but there's not one. All right. And just going through it, I mean, I've reviewed the files, but we've got 3 cases, 21 CF 3096, child neglect, and possession of a controlled substance without a prescription. I've reviewed that file. And then we've got, while on probation in that case, we get 23 CF 1405, smuggling contraband, which was narcotics, including fentanyl, and giving false ID. And then while on probation for that, there's the newest case, but also a probation case still, 24 CF 961, 2 counts possession of controlled substance, possession of drug paraphernalia. I've looked through her history as well. I mean, Ms. Holly, you've got a serious drug problem. It's been persistent throughout your adult life. I'd like to say there's something that can be done that would give you the treatment you need, but the attempts have been made. And at some point, we can't just keep coming back on new cases and new VOPs and new community control. And this was a case where you pled and had your suspended sentence kept on there a second time, and then in less than 2 months, there's another positive test. And frankly, I think that this is still escalating. You went from, opiates to now fentanyl, which is probably the most destructive force that exists in this country right now as far as what it's doing to people. The fact that it's so somewhat easily obtained, I'm not saying I'm protecting you from yourself at this point, but I'm concerned at what would happen if you went back on supervision, to be honest with you. So does she want to say anything before I pronounce sentence?
Judge, she is asking to address that.
Go ahead, Ms. Holly.
Yes, stand up.
Is there any way that I can get some kind of treatment?
I mean, I'm not going to debate it with you, but that you've had those opportunities, ma'am. And this is your third case in 3 years, and it's all related. And then we're not even talking about, again, what your record is of again, the vast majority of your adult life has been involved with these types of cases.
I understand that. I really do want to be better and to do better, which is truly why I kept reporting. Instead of running away like I normally would have, I really am trying I just need the tools. And I don't exactly understand.
You've been given the tools, at least access to them. You were involved in ECLC.
And I went, when this happened to me, I went immediately when I found out and talked to people about it. I did not know I was going to test positive when I went to probation, or I wouldn't have I would have ran, but I didn't know that I was going to test positive. Like, in my past, I've always ran. This is the first time that I haven't, and it was because I've really been trying. I don't exactly know what to say, but I do want you to know that I have really genuinely been trying to do better, and that's why I've tried to face it, and I really didn't want to talk about what had happened to me because it really has messed me up, because I had never had anything like that happen to me before.
Again, I don't find it credible, ma'am. You didn't report it to anyone. You didn't take any pictures. You didn't do anything to preserve any potential evidence, all because of this. You're afraid of this mystery man who you still haven't named.
His name is Mark Price. I knew who he was the whole time. I never had any doubt about who he was. It was the other guy walking away from him that I didn't know, but I've known from the beginning who it was, and I'm afraid of him, which is why I didn't report it to anyone other than to Miss Claw and to the couple of people that I knew that I said something to.
Well, I don't know that you reported it to anybody else, because none of those people testified, and it wasn't explained to probation when you tested positive that, well, I wonder if it was from that time I got attacked.
Miss Claw came with me to probation.
I understand, ma'am, but she didn't come in to testify today.
Well, Judge, I didn't call her because it was after the drug test. If
she would come testify.
All right. Anything else?
I don't have anything further, Judge.
All right. I'm going to give you this suspended sentence that's been deferred previously. It's going to be 30 months Department of Corrections. Court costs or the VOP fees, it's $100 per case, $150 for the PD fee. Those will be reduced to judgment.
Yes, Your Honor.
All right.
Thank you, Judge.
Anything that I've missed?
No, Your Honor.
All right.
Jay.
I'm sorry, Ms. Holly, you don't need to be fingerprinted, but also you have 30 days to appeal the judge. Hold on, can we quiet down for just a second so I can say this? Ms. Holly, you've got 30 days to appeal the judgment and sentence of this court. If you can't afford it, an attorney, one can be provided for you.
Formally,
Credit for time served.
formally pled.
We've got Gormley still.
I didn't sign the thing. Here.
Oh, that's right, he wanted to, okay. No, we were talking about pleading, but he needed time to read the.
Yes. And this is the score sheet, Mr. Williams, that I was given by Ms. Hutchins. We have to fix the judge's name because he's an older one and the date, but that's what she gave me.
Sir, I'll let you look over this. It's the same one that's in your file. So it'd be the same one that Mr. Gibbs would have provided to you.
Okay. I'd like for, if it's possible, when I get.
Right. You can go to the clerk's office, and they'll take the amount that you owe, and they'll set up a payment plan for you.
But I want
Okay, how long do you feel like you'd need?
probably 4 months.
I'll ask him for it.
Upon voice from DLC, and then it will state, I will have something in writing stating that on my court minutes.
Right, the judge is going to announce that as part of the
Okay,
sentence.
all right, thank you, sir.